Yes. Lord, I'll sum up in 15-20 minutes and Lord, on the last occasion, yes, Lord, on the last occasion, I had mentioned that it is very clear that the present system of Section 34 has created more problems than it has solved. It was intended to bring in a simple system of arbitration and so on, but it has actually created more problems. There's a rigidity in 34, which has to be addressed. And that rigidity has been partly relieved by the legislature, partly relieved by the legislature, by inserting 34(2)(a), which is an admission. 34(1) by itself may not address problems which one may face, the courts may face while dealing with domestic awards. So Lordship will appreciate that 34(1) and 2, 34(2) deal with international awards and domestic awards, that is ICAs and domestic awards. But 34(2)(a) deals only with a domestic award. And there, Lord, they say that you can set aside the award to the extent of patent illegality, which was not the ground for 34(1). For 34 ground, you got the fundamental policy of India, shocking the moral conscience, etc. Now, my Lord, the point I'm making is this. Today, my Lord, we need not go into what is the meaning of patent illegality, what is the meaning of fundamental policy. That is not the remit in my humble submission of this bench. I am putting, sorry, Lordship, see.
Please continue.
Yes. Lordship, see 34. But the point I'm making, the Lordship sees 34.
But 34 is an additional ground. It's not really a ground which permits. 34(2)(a)
yes,
is an additional ground
for domestic arbitrations.
But it does not permit segregation or division of an award per se.
Per se, yes. Therefore, your Lordship is right. What your Lordship is referring to 34(2)(a)(4), which says that, yes, maybe that's what your Lordship is. But my humble submission is, the point we are making, and I think there cannot be an argument against that the power to set aside will necessarily include the power to partially set aside. That's a well-settled principle in our Constitution. The larger power includes the lesser power. You can't say either you set aside everything or don't set aside. To give a practical example, we'll have to see the law as to how it applies in practice. Now, all of us who have done arbitrations at some time, it is, in a sense, something like a civil case where there's a claimant instead of a plaintiff, we call it a claimant. Then there is a counter. Issues are framed. Invariably, my experience is the issues are framed by the arbitrators. If there's a counter claim, they'll take it together and issues are framed. Now, the point I made last time, at the time when the bench rose, was take a hypothetical case where the arbitral tribunal frames, let us say, 7 issues. Based on the pleadings, they frame 7 issues. And out of 7 issues, let us further assume that 2 issues, if I may use the word, are infected with patent illegality. They are infected with patent illegality. Now your Lordships have to decide. In such a case, do I set aside the whole award because it doesn't say partly, or the court can say these 2 issues are severable. They are severable. They are on a standalone basis. And I need not relegate the parties on all 7 issues back to the tribunal just because 2 issues are infected with patent illegality. Lord, my humble submission is the word set aside can't be given such a rigid meaning as to make it inflexible and put it into a binary of a black or white. And once there is a patent illegality, the whole award goes. So my first request is, Lordship may see set aside must necessarily include partially set aside. That must be given, power must be given to the court. And I would submit it is inherent in the court. That inherent power is there. Lord, I'll show Lordship a passage from Ashok Hurra and Rupa Hurra in a different context on curative, where Justice Kadri says, we can't, once we see a patent injustice, we can't be a silent spectator and fold our hands and say we can't do anything. You can do. Lord, on this partial setting aside, I don't think there can be much of a, in my humble submission, much of a problem, because if the court is faced with severability, then it can't be said that if it's 34.2, I will sever it, but if it is 34.2, I will not sever it. That will be an illogical answer. That if I'm a domestic award and I'm under 34.2, severability applies. But if under 34.2a, a certain sense of rigidity comes in, that cannot be the answer. The larger, bigger problem on a day-to-day basis is this, Lord.
But then you are going on the assumption,
yes,
that severability is possible.
Yes, that's my first limb. What I'm saying is, Lordship will imagine a chart, patent illegality, severable, non-severable. If it is severable, then to the extent of severability, partially set aside the award. That is the first submission. Now the larger problem now comes in. Suppose there is a patent illegality. Now first division is severable patent illegality, non-severable patent illegality. Now I'm coming to the second classification, sub-classification. There is patent illegality, and it is of 2 types. It's a curable patent illegality and a non-curable patent illegality. But in my final submission, I'll draw the chart and give it to you. So I wanted to make the chart after getting your Lordship's reactions and hearing the other side also. And I'll show with examples how this court, where the illegality is curable, they have not set it aside and sent it back. They have cured it here and now. So what do I mean by curable and non-curable? What I'm submitting is, if the patent illegality goes to the root of the matter, just imagine Lordship is now hearing an appeal from the High Court. Lordship finds the judgment has to be set aside. There is nothing else can be done but to set it aside. The judgment is so unsustainable that the court sets it aside. At the same time, a lot of times innumerably, Lordship has partly allowed the appeal. Partly allowed the appeal. So my submission is, if the patent illegality is curable, why can't we say that the inherent power of the court includes the power to cure that illegality alone? And now if a Lordship reads the section carefully, 34, I want to make a submission that only if is not confining the powers of the court, the only if is a maintainability. If you just read it with me 1 second and I'll go to my last part. 34.1 and 34.2, Lordship will kindly see. 34.1 says, recourse to an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 or subsection 3. So that means that the setting aside can only be on the basis of an application. Can't be a suo motu. Now, an award may be set aside by the court only if the party making the application establishes on the record. It's been substituted for proof. So my humble submission is, actually an arbitral award may be set aside by the court. There are 2 grounds. that only if must be linked only to clause A. Lordship will appreciate it should be linked only to clause A, because unless the applicant brings it within 1, 2, 3, 4, 5, the application will not be maintainable. Now come to B. The court finds that. The court finds that. So typically what we do in real life, in day-to-day, is in our 34 application, if the award is suffering from an infirmity under 34(2)(b), we also add that as a ground that the award is contrary to policy of India, or it's not capable of settlement under the law for the time being in force. That's not an arbitrable dispute. That we added as a part of an application. But that is not necessary for the maintainability. What I'm submitting is B indicates that there is an inherent power given to the court to address a case where the arbitral award is on a ground which is not capable of settlement. Suppose the party had not taken that ground at all. He satisfies 1, 2, 3, 4, 5. He doesn't take the ground that it is not capable of settlement. Like the Lordship has held, it's complete fraud, forgery, it can't go for arbitration. He takes that point. Or it's in conflict with public policy. That ground is not taken. Can a Lordship say that, no, I'm bound by the pleadings? No. Lordship will say, look, I see the award. I see it's non-arbitrable. I see it's contrary to public policy of India. Therefore, I can interfere and set it aside. There my submission is in 34(2)(b). Also, it is not all or nothing. If there are 4 disputes, 2 are not arbitrable, those 2 can be set aside. If the remaining 3 are arbitrable, let it go. Let it continue.
No, that's provided in clause 4 itself. So
no, but not in 2B.
Not in 2B.
Yes.
Now, the difficulty, there are 2 ways to interpret, though it's not strictly within our domain.
Yes.
Or the reference. But if one looks at subsection 1,
yes,
the recourse to the court against an arbitral award can be only made on an application for setting aside of the award in accordance with subsection 2.
Yes.
Now, this will mean an application by an aggrieved party.
Yes.
But if we look at B, the court finds that, so it, logically speaking, it says it will be only unless the party has taken recourse to an application in terms of subsection 1, the court finding will not be there.
Correct. The court can't see when award is coming in the media, like I take under Article 2.
Or even if, say, executing court cannot.
Your Lordship is right. At the order 21 stage also, he can't say, no, it's contrary to public policy, therefore I'm. Because by that time it becomes final and binding.
Correct.
Yes. No, what I'm arguing is. Sorry.
The court hearing at 34 is not a creature of this statute. It is a court which independently exists.
It's a 2E court.
With its inherent powers.
Yes.
Under the old act also, 151 has been invoked wherever statutory provisions were, found to be deficient. Probably Ramji Dayawala in context of 34.
Yes.
Additionally, 154 to stay the suit. So we will also ask them, would 151 CPC be available to the court, because we can't treat the court as a tribunal which is a creature of a statute.
Yes.
It is a court which exists with its inherent powers. Additionally, the power is conferred in this statute. Power is drawn from the statute in excess of its ordinary powers of a civil court.
Yes.
So, what stops a court from exercising 151 powers where interest of justice warrants?
But can a Lordship also see?
Didn't provide in the old act.
Yes.
Scenario which invoke 151 to stay.
Yes. And your Lordship is right, because definition of court is the court of the ordinary, the highest civil court in that district. So it could be the charter court, or it could be like in Bombay, Madras, Calcutta and Delhi, it is the high court. And in Bangalore, for example, we go to the district court. City civil court.
Principal judge of the city.
Principal judge of the city. In Bangalore, Andhra, we all go to city civil. Nagpur won't go to high court.
Original site is only for me,
Only
only for Mr. Kambad. If read arises from, say, Mulund, it will go before a single judge. And if it arises from Thana, just across the road, it will go to the division bench.
No, from what your lordship is saying, if it's a Madurai bench, then again 34 won't lie. We'll have to go to civil court.
Because it lies only to
Quite possible. Principal court of that
Principal
place,
court.
yes. So, my lord, what in the light of what my lord Justice Vishwanath asked, recourse to court, I mentioned yesterday on section 9 just before closing. Now,
So you can come the section 151 route. not
151 route also. Get the CP. 151 route also. Lordship will see 151. The same provision is also contained in Rule 6, Rule 9 of the Company Court Rules. In the Companies Act, they say so. They say that the court will have all the powers to do justice. You take Regulation 44 of the Income Tax Tribunal rules. Tribunal has all the powers to make in the interest of justice. Same thing in the CLB regulation. So what I'm saying is they confer it on a tribunal, but that need not be conferred on a court because the court has. Now the definition of court in 2 is 2(1)(e). Court means in the case of arbitration other than international commercial law, principal civil court of original jurisdiction in the district includes the High Court in exercise of ordinary civil jurisdiction, having jurisdiction. Now, my submission is following following Dulabai's case, old Hidayatullah judgment of Dulabai, unless the powers of the civil court are explicitly taken away, they will always continue.
implied that it will continue.
Pardon me?
It is implied that it will continue.
It will imply that it will continue. For example, the latest Companies Act, there is express provision that no civil court shall have jurisdiction to deal with matters of Companies Act. No civil court. Same thing, you take all the tax statute, no civil court shall. So the jurisdiction is ousted. So the law is basically jurisdiction is there. It has to be ousted. Here what they say is recourse to the court is there. So court has the power to grant relief. But that relief will be granted only on the basis of an application, as my lord the Chief Justice mentioned. Absent application, you can't act. But once the matter is in court, B expressly says the court finds that. And then they further amend.
Even if that ground is not raised.
Pardon me?
Even if that ground is not raised, but if the court finds that
Yes,
it
yes.
suffers from the clause 1 and
Yes,
of B,
yes.
the court will be empowered to exercise the jurisdiction.
Yes. No, this is not like the tax dispute. The question of law has not been raised, therefore I will not answer it. That is not the point. There also, will not they say in 260A, the power of the court is like the power of a civil court. Lordship knows 260A subsection 5. Even if you don't raise that question, the court can still deal with it. That is so throughout the theme is that you maintain the powers of the civil court. So I'll just complete my submission by saying recourse to a court means recourse to a civil court. Keeping in mind section 9 read with section 151. The inherent powers of the court to do justice are always there, and therefore set aside must include partially set aside. Now I came to this issue, I'll come back to the issue of severability. Now in 34. Therefore, my lord, my submission is that the recourse to the court under section in the 34, there is an implicit power of the court. To what extent it is taken away is limited by 34(1)(2) and 34(4). What are the limits to which the court cannot go? They are set out in the explanation. Kindly come to 34, explanation 1. Please come to explanation 2 of 34(2). For the avoidance of doubt, the test as to whether there is a contravention of the fundamental policy of India shall not entail a review on the merits of the dispute. So this is like a red line which says that, at the heart of the day, they say don't make it a section 96. Don't convert it into an appeal. And my lord, perhaps the best discussion is that Lala Bansidhar's case from Delhi High Court which came. What are the types of jurisdiction? There is an appellate jurisdiction, there is a revisional jurisdiction, and there is a reference jurisdiction in the old income tax cases where the High Court's jurisdiction is only on a question of law. The tribunal continues to be in session of the matter. The High Court decides the question of law, and then the assessment order is passed in the lines of the High Court order or the Supreme Court order. So you have appellate jurisdiction, revisional jurisdiction, reference jurisdiction, and this is another kind of a jurisdiction called application jurisdiction, where it's a new type of jurisdiction. I'll give the Lala Bansidhar's case, very detailed discussion on what are the types of jurisdiction the High Court had. Let's get Lala Bansidhar. So there's an appellate, reference, revisional, and now it's an application where the power is limited. And what are the limits? One explanation is you can't do a review of the merits of the dispute. So as the Lordship put it, you can't get into the merits. You can't step into the shoes of the court. Lordship will note section 107 of the CPC says the power of the appellate court is as much as the power of the civil court. Under section 107 of the CPC, the appeal court can do everything which the law can do. Coextensive. This is not a 107 power because this is not an appellate court. So Parliament says, look, when you're discussing whether it's contravening fundamental policy, don't go to the review of the merits. Now, please see 2A proviso. Provided that an award shall not be set aside merely on the ground of an erroneous application of law or by a reappreciation of evidence. And it's erroneous application of the law, not a complete error of law itself. You apply the law erroneously. This is like the old Anismini case. Once you have jurisdiction, you can err within the jurisdiction. But suppose you apply the law completely wrongly, then your lordships have held it is perverse, irrational, and so on. So my submission is, section 34 has inherent power of the court. It is not taken away explicitly. The word is may be set aside. And the two explanations give a yardstick as to what can be done. Now, please come to 34(4) also, where also there's an indication. Now, 34(4) came bodily from the international commercial arbitration. Obviously, my lord, if the award is passed in ICC Paris or another country and it comes for enforcement to India, then what happens? In an international award, you're not an appellate court. You're not a court like 2E court. The definition of court in the UCITRAL is an Article 6 court, the court of that particular country. That court was not given the power to, they could set it aside and they could not enforce it. So what happened is, if it came before the court where the award was passed, they could be set aside. If it goes for enforcement, then the same grounds are there. For setting aside enforcement, same grounds are there. Now here what they did was, they said you can send it back to the tribunal. I'm requesting your lordship to read 34(4). What does 34(4) say effectively? That instead of setting aside the award completely, because 34(4) will come only when an application is filed under 34(1). But if an application is filed to set aside the award, typically the other side will say, don't set it aside fully. Here is a ground to set aside, but that ground can be remedied by sending it back to the tribunal. Can we not say it's a curable defect? 34(4), because setting aside is the death of the award. That is the last remedy. So what the 34.4 contemplates, instead of going to the extreme step, now the ground for setting aside the award can be, when they had 4, when they inserted 2A, they kept 4 as it is. So the ground to set aside the award can be a patent illegality ground also. Not sure appreciates that. They kept 4 as it is. Now the grounds to set aside the award are both in 34.2 and 34.2A. So the court will examine, the 34 court will see, look, this is the ground, yes, award can be set aside. Then you ask the next question. Can I avoid the extreme step by sending it back to the tribunal? My humble request is, why not leave it to the discretion of the court to say, look, this is a matter where I need not send the parties back. If I can modify it, I can make change here itself, I can sustain the award. Why can't that power also be read into the inherent powers of the court? Why send it back? Because Lordship will see a practical difficulty. By the time the matter comes to the 34, 4 or 5 years have passed. And I spoke to my friends who deal extensively in arbitration. He's saying it's very, very often unworkable because the tribunal.
There's some difficulty in accepting this argument.
Very well.
Because if we accept that curable defects referred to by in your arguments, which the court can rectify, are relatable to subsection 4 to section 34, then it will lead to difficulty because 34.4 provides for a specific remedy.
Yeah. No, I'm not saying that you should
It
bypass.
can be argued by the other side that when a specific remedy and a method of providing for that remedy is, then we cannot
bypass it. Yeah.
bypass it.
No, what I'm submitting is, this is one indicia or one indication that if there is a ground to save it, because what I'm saying is 34.4 doesn't contemplate setting aside completely. 34.4 is a exit route or a window where you save the award by curing the ground on which it can be set aside. Now your lordships have interpreted 34.4 to mean it can't be a second bite at the cherry. You can't use 34.4 to make it like a review court and re-argue that case. So where the point is, now let's visualize what could be the ground to set aside the award. It could only be under 34.2 or 34.2A. Because patent illegality is a huge spectrum. It can be from a small thing to a large thing. We don't know.
But when subsection 4 describes a particular procedure.
I know that. I'm not saying that.
As a Nazir Ahmad principle, when a law requires to be.
Yes, Taylor versus Taylor thing done in a, yes, Lordship was right. Taylor, Singaram Singh, all the line of cases are there. You can't. I'm not saying that the court usurps the power of 4. I'm not saying that. The very purpose is given is, if this, now I'll tell you what, Lordship, what happens. Suppose the ground for set aside evidence is, suppose some documents have not been considered. In one issue, certain critical documents have not been considered. The other side says this issue has to be set aside because this critical document has not been considered. That has a material bearing. Now the 34 court can't go into appreciating evidence, summoning the document on. They say, all right, this document has not been considered. We'll send it back to the tribunal. Let them consider these documents and then decide the issue. That's what is 34 is contemplated. I'm on an illegality like a legal illegality, which doesn't require re-examination of evidence. I'm only saying, as my Lord Chief Justice is right, we can't say because 34.4 is there, the court can do the same thing which the tribunal can do. That is not my argument. That will be a wrong interpretation. I'm only saying there are various indications in 34 to say setting aside the award is the last resort. Wherever you can save it, try to save it. The only limitations are don't reappreciate it, don't do a review on merits. So my last submission, and I'll conclude with this, my submission is this. Partial set aside must be there. If the award is severable, my submission is, if the award is severable, because typically what will happen is multiple issues are there. It is not that all issues are patently illegal. Invariably, it will happen that 1 or 2 issues become bad. Like we all seen first appeals. When you go for a first appeal, the first court sees what are the issues framed, what are the answers on the issues, and then we argue that matter. All of us have argued first appeals and second appeals. That's what we do. But my submission is, apart from the classification of severable and non-severable, I'm now going into 2 points because curable and non-curable. Ultimately, we have to make sure that arbitration becomes a vibrant alternative force. Today, what's happening is with this kind of interpretation of saying that you can't touch it at all and all that, then people are going to be very hesitant to go to arbitration. And if I'm going to have an arbitration clause and after 7 years, I'm going to be sent back, no, now you set aside, start on your own, then what is the purpose? The whole purpose is completely lost. Then it doesn't become an alternative dispute mechanism. It becomes a dispute mechanism which will be forced upon me because I have no other power but to listen to the contracting party. If I have to get the contract, I have to sign that arbitration clause. Now, the second submission I'm making is, yes. Once you accept that there is a power to partially set aside the award, then my humble submission is leave it to the court because the limits are given here. Don't review on merits, don't reappreciate evidence, don't correct errors of law, application of law. Those limits are there. I'm saying, please examine this point, which I'll conclude with this. In my example of 7 issues, suppose the 2 issues are not severable. That infection affects the whole award. It's not severable. Then what does the court do? My humble submission is the court must then examine what is this patent illegality in these 2 issues which is infecting the whole award. If that illegality, patent illegality, doesn't require reappreciation of evidence, doesn't require correction of application of law, doesn't require a review on the merits, those 3 constraints, then the court can always say, look, instead of setting aside the whole award, I will remedy the illegality to the extent the illegality can be corrected, like a course correction. The award is off track, bring it on track and save it. And it has been done more than once. Lordship will kindly see both the statements. I'll give the example. Lordship will just note. Lordship will note citation. Indian Oil Corporation versus Ganesh Petroleum, 2022 4 SCC 463. 2022, volume 4, SCC 463. Here what happened was, the award altered the terms of the lease. They made it 20 years into 9 years or 10 years. They changed the rate of rent. Now you altered the whole thing completely. What did the court do? They said, no, if it's a 20-year lease, it should go back to 20 years and restore the rent. So what they did was, the award was modified to make it conform to the lease agreement, and it was then allowed to stand. That has happened. Then take State of Chhattisgarh versus Sal Udyog, 2022 2 SCC 275. The award did not consider an applicable government circular. It was modified to bring it in terms of the circular. Two more examples I'll give. Sangyong, the Honorable Supreme Court says majority's award is wrong. I'm taking the minority award as the correct award, which I think is a very extreme example of modification. Suppose there's a dissenting award. Under 34, can the court say that there are 2 awards in front of me? I will sustain the minority award. Or do you set it aside fully and send it back? Maybe one can take the view that if the majority is so patently wrong and the minority is a well-reasoned award, that's what been done by the Supreme Court. And lastly, Hakim. Not as far as Hakim is concerned, my humble request is.
Third one, you've not given us the citation.
Sorry,
Sangyong.
I'll give it in a minute. Sangyong and McDermott, I'll give both the citations. Sangyong is 2019. 15 SCC, 131, and Hakim is of course in the referral order, 2021, 9 SCC, page 1.
2021,
2021, 9 SCC, page 1. This is part of the referral order. That's Hakim. That is National Highways versus Hakim. And McDermott, which is Justice Sinha's judgment, 2006, 11 SCC, 181. 2006, 11 SCC, 181.
I think I'm party to Hakim.
Pardon me?
I was part of the bench in Hakim.
Part of the in Hakim, yes. And I think Mr. Justice Sinha was the counsel in Hakim.
Counsel.
no, I was not there.
Yeah, she's counsel in? Sorry. Yes,
What is the page number of Sangyong?
131.
13.
Now, my lord, I have also referred to the case law compilation which we have given. Please see Vedanta. Vedanta, if the court master can put it up. Where is Vedanta? Yeah, wait. Vedanta 2019 11 SCC, page 463,
2019,
11 SCC 46.
It's 416 of a common compilation.
465, it is page 416 of the common compilation. All the cases are in the common compilation. Now, please come to para 11 of this judgment. If they can put it up. Twenty 1911 SCC 465. Please see para 11. That's important. May I read para 11? Read para 11. Yes. Yes. Please see para 11 in the screen. Lordship will see para 11 in the screen.
I've got the book.
Courts may reduce the interest rate awarded by the tribunal where such interest does not reflect the prevailing economic conditions. That's one part. Where it is not found reasonable or promotes the interests of justice.
Now, till this one, there are 2, 3 things. Can the court also increase the rate of interest?
Pardon me?
Can the court also increase the
Yes,
rate
my
of
answer
interest?
is yes, because suppose the arbitral
Just one.
Just
Just one. Now, if one goes by that, that means this is a complete case of merit review. This is a complete case of merit review
No, I'll tell your lordship why.
because
Sorry.
it is rate of interest has an element of always has an element of discretion. Rate of interest always has an element of discretion until unless by statute that
Or by contract.
or contract is taken away.
Yes.
And as far as pendant is concerned, it's always under 34 also a matter of discretion of the court. Now, if one looks at the rate of interest provisions also, it says that where the arbitrator has not awarded interest, post-award rate of interest, then the statute itself prescribes the rate of interest. Can the court then read down the rate of interest? Suppose the award does not prescribe the rate of,
Can I give an example?
but because then it provides that. So in this case, will you not read down that the discretion of the court is taken away? Because by default, if the arbitrator has not awarded post-award rate of interest, then there is specified rate of interest.
But on the interest issue, there is a problem here because the contract is 18%. Very often, if the other side is a public sector, then the court says.
The reason why I say the increase in rate of interest, because most of the government contracts, there's a specific stipulation, no interest will be awarded.
No. Let's come to a contract where interest is awarded.
So the reason why I asked you
I
that
know.
was, and they're judges of this court, arbitrator is bound by those conditions.
Correct. In fact, in many of the government contracts, other problem is, as a tax lawyer, they say that the price is all inclusive. Even if there's a hike in the taxes, you have to bear the cost. It also has been held to be valid. I'm not on that. I'll tell you a practical problem which we have faced in Madras. Many of these finance companies are there. Now they give loans for sale for car and motorcycles. And now what they say, the interest is 18% per annum. Because they have to borrow at 12% unless they have the arbitrage, they can't sustain. There is a clause that if you default for more than 3 months, the interest becomes 24% or becomes 36%. Now, in the light of what your lordship said, in many of these things, there are arbitrations where they appoint lawyers to the small arbitrations. The default is 2,80,000 like that. Very often they seize the vehicle, only the balance they have to recover. Now, my submission is if the contract says that a defaulter has to pay instead of 18, 24%, and if the arbitrator awards only 18, ignores the contractual rate, my humble submission is the court can change it in the interest of justice to 24. Why not? That's my question. And in fact, our High Court or the Honorable Supreme Court has held, you can't have a separate yardstick for government companies. You can't have some kind of sympathy. If they have the clause, then they have to also have the thing. But to answer your lordship question, can you increase it? You can increase it to make it in terms of the contract. Only one thing is there, my lord. On interest, please come to section 28 of the Arbitration Act. That's very important, which we lose sight of. Section 74 of it. 28 is again borrowed from the UNCITRAL. They modified it in India. 28 is very important. Again, it is peculiar for domestic arbitration. May I read 28 1A, my lord? 28 1 small a. The lordship's got it, my lord? Yes. Where the place of arbitration is situated in India, in an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. Now, this is a mandate given by the legislature. Once the arbitration is being held in India, if the place is in India, then the substantive law of India applies. Now, lordship gave the example of interest. What does the Contract Act say? The penal interest, the lordship takes section 74 of the Contract Act. They say that a clause, suppose I say it's 18%, but if default it is 48%. Suppose I make it highly issued. Then the Contract Act says such a law is in terrorem. It's in the nature of a penalty. It is not permissible. So the arbitrator can always say he has to decide in accordance with the substantive law of India. Section 23 of the Contract Act. If a clause is against the public policy, the agreement is void to that extent. So I am saying that the patent illegality can also be seen from 21A. If the arbitrator has ignored the substantive law of India, then the remedy is either to set aside the award or to make sure that it falls in line with the substantive law of India. Why set it aside? If you can just, like my lord the Chief Justice gave the example of a formula. The arbitrator has not completely applied the formula, he has missed one particular part of the equation. You can just change it to that extent. Why send it back for that purpose? That's my submission. So my lord, I'll just conclude by saying that one more thing as far as Hakim is concerned. My lord Justice Vishwanathan asked the question, what about reversal? Set aside and reversal. My submission is, suppose the particular issue in the arbitral award has taken view X and the correct substantive law is view Y, then it need not be set aside. The arbitral tribunal, the section 34 court can simply say, look, I'm ignoring X, I'm going to put it as Y, which is exactly what your lordship did in Sal's thing. You said, you ignored the circular, I'm applying the circular, I'm doing it. To that extent, it is a reversal of what the arbitral award did.
Is that not varying? Is varying different from modification?
But we thought about it, we discussed it. But basically, we are on a fundamental basis. When the lordship partially sets aside the award, are you not modifying the award? So are we not on a question of semantics? What is modifying? What is varying? In the long run, we will have to come to a situation where we adopt some of the clauses like Singapore, UK, which learned solicitor has given, where there is the express power to modify the award, vary the award. Please see section 48 of the Singapore law, which it says, he has quoted. It says the court shall not modify the award under any circumstance, except as provided in the Act. That's 48 of the Singapore Act. 49 then says, a domestic award can be varied, modified. The lordship sees learned solicitor's notes. You quoted section 48.
48 is
There is a bar.
in principle similar to section 5 of our Act.
No. 48 says,
47.
no, see, 47 says, Lordship will kindly note section 47. In Singapore, the court does not have jurisdiction to confirm, vary, set aside, remit an award on arbitration and agreement except where so provided under the Act. And provided under 49, and under 49, they say the court can, in that on appeal, the court can confirm the award, vary the award, remit the award in whole or in part, set aside the award whole or in part. Singapore 49(8), 49 subsection 8. Therefore, my lord, my humble submission is, ultimately, as I gave that note, I would request the court to add the words. I gave the chart on the last occasion, where repeatedly the court have added a few words here and there to sustain the award. And I also mentioned the court, Justice Vishwanathan noted it, on Seaford Court Estates with Lord Denning. Can I take that passage? No, I'll just give it in the course of my reply. Well, what Lord Denning says is, he says, acts of parliament are not made with divine prescience. English language is an imperfect instrument. So the act of legislature cannot cover every possible eventuality. Will the court master have the Queen's bench? Otherwise, Lordship will note the citation. Lordship will just bear with me. I'll just give it. The C4 Court Estates Limited versus Asher, 1949. 2 all ER, 1949, 2 all England reports, 155. Last time I gave it to the court master. 155. And Lordship will then come to the concurring judgment of Lord Denning at page 164. If the court master can put it, 1949, 2 all ER 155, I can show it. Otherwise, eh? Yeah.
All England reporter, not all India reporter.
All England report.
All ER.
All ER. May I just read that passage, Manoj?
Yes,
Can I just read it and I'll conclude?
yes.
It's at page, starts at 155, Lord Denning's concurring views at page 164. Very nice passage. I'll read, Manoj. Whenever a statute comes up for consideration, it must be remembered that it is not within human powers to foresee the manifold set of facts which may arise, and even if it were, it is not possible to provide for them in terms free from all ambiguity. The English language is not an instrument of mathematical precision. Our literature would be much the poorer if it were. This is where the draftsmen of Acts of Parliament have been unfairly criticized. A judge, believing himself to be fettered by the supposed rule that he must see the language and nothing else, laments that the draftsmen have not provided for this or that, or have been guilty of some ambiguity. It will certainly save the judges trouble if Acts of Parliament were drafted with divine prescience and perfect clarity. In the absence of, now this is the problem, in the absence of it, when a defect appears, a judge simply cannot fold his hands and blame the draftsman. He must set to work on the constructive task of finding the intention of Parliament, and he must do this not only from the language of the statute, not only from the language, but also from a consideration of the social conditions which gave rise to it, the mischief it was supposed to remedy, and then supplement the written word so as to give force and life to the intention of the legislature. To put it in homely metaphor, a judge should ask himself the question, how, if the makers of the act had themselves come across this ruck in the texture of it, they would have straightened it out. He must then do as they would have done, that legislature would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. So my humble submission is, by adding 3 words as I suggested, lordships are not altering the fabric, you are ironing out the creases. I'm grateful.
My Lord's permission, may I follow with that? But I am appearing in IA 9364 and 9401 of 25. Not, I've also prepared an additional compilation of just the judgments that I wish to show my lords, which I will take my lords. Earlier I had filed a 3-volume, but I think this is much more handy. Just share it. The aim of arbitration, as my lords have held, in the interplay with Stamp Act judgment, is to provide speedy, efficient, and binding resolution of disputes. There's a delightful passage from Redfern and Hunter, which my lords have also quoted there, which starts with the advantage of arbitration is expedition where the law is slow. The Act itself, apart from the objects and reasons, has a lot of internal evidence to show that speed and finality forms the fulcrum of the Act. Very briefly, Section 29A, the time limit of 12 and 6 months. 29B, fast track procedures. 34(6), disposal of 34 within 1 year. All these show that the intent of Parliament is speed and, of course, finality. Now, the question before your lordships is that if under 34, the court only has the power of annulment of an award, either wholly or partially, it would mean that a successful party who has succeeded, say, in 90% of the matter before the tribunal, has failed on one question of law, has then succeeded in the 34 in getting the finding of a court that this is a patent illegality, would then be relegated to restarting the entire process all over again from day one, which is an immeasurable cost, hardship, and completely contrary to the object and purpose of the Act. It would undermine the very idea of arbitration itself. Now, today, your lordships are faced with this situation. Certain foreign jurisdictions, as the learned solicitor has shown, has got express provisions to vary. Our Act does not have an express provision to vary. And though the Dr. T.K. Vishwanathan committee has recommended that, that recommendation has still not been incorporated. So we are left with two major arguments against giving any power to modify to a 34 court. Let me state them straight away. One is that there is no express language in Section 34 itself. And coupled with Section 5, one is restricted only to the express language of 34. And the second is an alarmist one, that if a court allows modification, the floodgates will open and you will convert 34 into an appeal, which it is not. Let me address both of them. First, the source of the power. I intend to argue in two compartments. My first compartment will be that, in fact, 34 itself contains the power. And my second compartment will be that in any event, the inherent power, particularly of high courts that are constitutional courts of record under Article 215, is never taken away, even when they sit under a special statute like the Arbitration Act. That will be a second compartment. I'll deal with that separately. And then I propose very briefly to suggest certain guardrails to meet the floodgates argument, because I don't think anyone who is pro-arbitration wants a complete, unfettered, unguided power of modification. And my submission there is going to be that that power can be hinged exactly within the discipline of 34. So, for example, patent illegality is a ground on which an award can be set aside. To come to that conclusion, a 34 court would necessarily have to determine what the correct position of law is to determine that there is a patent illegality. The only suggestion is in those cases, without reappreciating evidence, without allowing a reconsideration of merits, permit the incorporation of that correct position of law into the award with only consequential modifications. Therefore, that is completely within the discipline of 34, not outside. Now, may I go first to 34 itself? 34(1) is the source of the power. 34(1) tells us that recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and 3. So to have recourse to a court, you can have recourse only via an application for setting aside. You can't simpliciter file an application of modification or appeal. You have to first fit within the discipline of 34 to even have recourse to the court. But what you then have is recourse to the 34 court. Now it is very well settled that even when the express words do not indicate a wider power, if the wider power of annulment is conferred on the 34 court, that would include all lesser powers. And a lesser power would include the power to modify under certain restricted circumstances. This, as your lordships have held in the Sakiri Vasu case, is the doctrine of implied power. Would my lords just turn for one moment to the very first judgment in this compilation? That is Sakiri Vasu, 2008, 2 SCC, page 409. At para 18 onwards. In para 18,
Para 18.
para 15. Para 15 is section 156.3 provides a check on the police performing its duties under chapter 12 CRPC. In cases where the magistrate finds that the police has not done its duty of investigating the case at all, or has not done it satisfactorily, he can issue a direction to the police to do the investigation properly and can monitor the same. Power in the magistrate to award further investigation under section 156.3 is an independent power and does not affect the power of the investigating officer to further investigate the case, even after submission of his report under 173.8. Hence, the magistrate can order reopening of the investigation even after police submits the final report. Then 17. In our opinion, 156.3 is wide enough to include all such powers in a magistrate which are necessary for ensuring a proper investigation. And it includes the power to order registration of an FIR and of ordering a proper investigation if the magistrate is satisfied that a proper investigation has not been done or is not being done by the police. 156.3, though briefly worded, in our opinion, is very wide, and it will include all such incidental powers as are necessary for ensuring a proper investigation. Then in para 18, it is well settled that when a power is given to an authority to do something, it includes such incidental or implied powers which would ensure the proper doing of that thing. In other words, when any power is expressly granted by the statute, that is impliedly included in the grant, even without special mention, every power and every control, the denial of which would render the grant itself ineffective. Thus, where an act confers jurisdiction, it impliedly also grants the power of doing all such acts or employ such means as are essentially necessary for its execution. I would respectfully submit that there would be an implied power in the 34 court to do everything necessary to save the award, even in cases where it finds that the whole award or part of it is vitiated by a patent illegality. And then para 20, in ascertaining a necessary implication, the court simply determines the legislative will and makes it effective. What is necessarily implied is as much part of the statute as if it was specifically written therein. So no need to write in any words. This doctrine allows your lordships to find that power in 34 itself, provided your lordships are satisfied that the idea of 34 is a recourse to a court, and the object and purpose of the act is to protect and further awards and to make the entire process speedy and final. In fact, your lordships may also invoke another doctrine, which is the doctrine of molding the relief. Your lordships will see the second judgment. Please turn to page 10. In ARCE Polymers 2022, 2 SCC 221. And at paras 22 and 23, your lordships have enunciated the doctrine of molding of powers. 22 first, at running page 24 of the compilation. In consideration of the facts of the present case, another important aspect to be duly noted is the power of the court's judicial authorities to mold relief, while holding that the general approach is that the claimant who succeeds in establishing the unlawfulness of administrative action is entitled to grant of a remedial order. The general proposition does not undermine the discretion which the courts or judicial authorities have in assessing, quote, what is fair and just to do in the particular case, to withhold the remedy altogether or to mold the remedy by grant of a declaration rather than a more coercive quashing, prohibiting or mandatory order injunction which may have been sought. So your lordship,
This is in respect of something else.
yeah, something completely different, but the doctrine of molding the relief would equally apply to 34. Is the 34 court left powerless to actually remedy the situation and subserve the object of the Arbitration Act, rather than to adopt the harsher remedy of setting aside and then leave parties to their remedy, leave them anchorless for the next several years to restart and relitigate the entire matter in arbitration? I would submit no, a court always has this power. Now, merely because there is no express power given in the statute, that does not imply that there is a prohibition. I'll come to section 5 later, but first, the lack of an express power does not imply a prohibition. Your lordships in Centro Trade, the third judgment at page 27, and Hindustan Copper have held exactly this. This is in 2017, 2 SCC 228 at para 23. At para 22 first, your lordships at page 42 have referenced the previous judgment of this honorable court in ITI, where the question before this court was whether the provisions of the CPC were applicable to the Arbitration Act or not. In response, this court observed that since there was no express provision excluding the provisions of the code in the Arbitration Act, it cannot be held by inference that the provisions of the code were inapplicable. Now, I must tell my lords that in fact a subsequent bench of 2 judges, I put it in the compilation, has doubted the correctness of this judgment and has referred it to a larger bench, which is, and that reference is still pending. But today the thought that the CPC could also apply has already been held by our lordships in ITI and not departed from in Centro Trade. Then para 23. In any event, we are afraid the passage referred to by counsel from First Day Lawson has been misunderstood and is even otherwise inapposite, since we are not concerned with a statutory appeal, but a non-statutory process agreed upon by parties that has nothing to do with court procedures. We are also unable to fully subscribe to the broad observation that acts mentioned in a statute are permissible, but acts not mentioned therein are impermissible. So the mere non-reference or silence at highest of an express reference of the power to vary or modify does not mean that that power cannot be read into section 34, because there is no prohibition. And we see, for example, the example of Singapore. My learned friend, the solicitor, cited section 47 of the Singapore Act in his written submissions at page 23, where there is an express prohibition to vary the award except as provided under this act. There is no such provision, and section 5 is not akin to such a provision. So I would submit that both by the doctrine of implied powers as well as by the doctrine of molding the relief, there is sufficient power in a 34 court to modify the award, albeit in a disciplined and restricted way. Let us take the question of severability. My learned friends fairly accepted that the general doctrine of severability is now well accepted under 34. And I've given just 2 judgments in this compilation. I won't read them. JG Engineers at item 4 That is at page 52, your Lordship's court, where at paras 24 and 25, certain claims were severed from other claims and they were upheld, and the other claims were set aside in the award. And the case of Jivani of the Bombay High Court, which is the last judgment, page 804, where a full bench again upheld this doctrine of severability in section 34. Now, what is important, in fact, my Lord the Chief Justice has been pointing this out, is that the express language of 34, 2A4, the proviso, which contemplates severability, very clearly is restricted only to severability of such matters that fall within the scope of reference and to sever those that fall outside the scope of reference. If that was the limited doctrine of severability, none of these judgments could have been delivered. Because these judgments are on the broader doctrine of severability. My Lord, just see 34, 2A4 for a moment. (34)(2) says an arbitral award may be set aside by the court only if A, the party making the application establishes on the basis of the record of the arbitral tribunal that, small Roman 4, the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decision on matters beyond the scope of the submission to arbitration. So the express recognition of severability is limited to what falls within the scope and what is outside. Yet, your Lordships and other courts have repeatedly applied the general doctrine of severability to save awards. And my learned friends accepted that that is part of section 34. So here is one classic example where the express language of 34 does not extend to such a power, but courts have always read that power in. Why have they read that power in? It is because they are cognizant that 34 is a recourse provision, and that the aim and object of the Act is finality and speed of dispute resolution. If an entire award had to be set aside merely because one portion of it was vitiated by, say, patent illegality, and the others were clearly separable, then it would not subserve the aims and objects of the Act, and would not then be a correct exercise of jurisdiction under section 34. That is why the general doctrine has well been accepted. Now, the doctrine of severability generally is nothing but modification of an award. An award starts on a particular footing. When it comes to the 34 court, it starts its life as a decree, as it were, on a totally different footing because one has severed parts of it. That is a clear modification and a power to modify. Indeed, your Lordships sitting in a 3-judge bench in Western Gecko, 2014, 9 SCC, page 263. 2014, 9 Supreme Court cases, page 263. Item 5 of this compilation.
Yes.
At page 72, paragraph 40, page 89, have referred to the power of modification, basing it on the doctrine of severability. My Lord, we'll just see para 40 for a moment, page 89. It is neither necessary nor proper for us to attempt an exhaustive enumeration of what would constitute the fundamental policy of Indian law, nor is it possible to place the expression in the straitjacket of a definition. What is important in the context of the case at hand is that if on facts proved before them, the arbitrators fail to draw an inference which ought to have been drawn, or if they have drawn an inference which is on the face of it untenable, resulting in miscarriage of justice, the adjudication, even when made by an arbitral tribunal that enjoys considerable latitude and play at the joints in making awards, will be open to challenge and may be cast away or modified, depending upon whether the offending part is or is not severable from the rest. So 3 judges have accepted that severability is a facet of modification. And that if the conditions for severability exist, there is a power to modify. Now, my learned friend, Mr. Datar, cited several judgments, Your Lordship, and obviously I won't repeat them, on even the power to add words. I believe with the submissions I've made just now, there's no necessity of adding words. It's part of the recourse and the setting aside power that you can sever and or modify. Because the first step in modification is severing. If you can't sever the vitiating part, then you can't modify. Modification only means that if I've already decided that this is the correct position in law, and completely erroneous and patently erroneous position has been followed, then surely one can replace that portion of the award with the correct position in law. Take a classic case of limitation. Let us take an award where a party has completely succeeded on the contract or the transaction. Evidence has been left. The facts are undisputed. Liability claim is quantified, undisputed. But the tribunal says it is time barred under Article so-and-so. Now, if the 34 court feels that in fact the wrong article has been applied and the period of limitation is longer, and if the correct period of limitation had been applied, the claimant and the petitioner would have succeeded. It would be a travesty of justice for it to relegate that claimant to a fresh arbitration, to run the entire gauntlet of trial and evidence all over again before a fresh tribunal, just with an application of the correct position of law. Therefore, I would submit in such cases, it is indeed the duty of the 34 court and well within its powers to make that modification. And I'm not today getting into a distinction between rate of interest. Is it rate of interest only that you can modify, or is it other things? My formulation is, please read in a power of modification, restricted to the guardrails and discipline of 34. That is to say, something that must be on the basis of the factual record and determination of the tribunal as it exists. No reappreciation, no entering into merits. But if you find that patently there is an illegality, which you have corrected in order to set aside the award, then why set aside the entire award? If the entire process of arbitration and award can be saved by merely incorporating your correct determination of law into the award. Your lordships have done that repeatedly, but under Article 142. Now, every matter cannot come up to your lordships under 142. That will be a flood of matters there. Therefore, I would respectfully submit, it does make sense to read this power into 34 as an implied power and within the larger power of annulment or setting aside, because 34, as 34.1 tells us, is a recourse provision. It's not just an annulment provision.
Secondly, the tenor of 34.
Yes.
Though the marginal note says setting aside.
Yes.
Read entirely with special focus on 34.4.
Yes.
Shows that the idea is to uphold the award.
I'm obliged.
Final power is really to uphold the award.
I'm obliged.
Though couched as setting aside.
And that is completely consistent with the object and aims of the Act. And my lord is right to refer to 34.4. If 34 only had a power of annulment, then there's no question of 34.4.
Otherwise, your implied power argument won't sit in, because the final power is to set aside. By modifying, the final power is not effectuated. In sum and substance, the power is really to make an endeavor to uphold it within the parameters of law.
I'm obliged.
In exercise of that final power, if there is a power to effectuate that final power, should the court be deprived of it?
Lordship, I'm grateful, my lord. May I adopt that as my submission, my lord? I'm grateful to the court for putting it so precisely. Now, the judgment in Seaford, which my learned friend read, I must just, for the record, point out also that in Bangalore water supply, 7 judges of our court have expressly accepted that principle. And that's the judgment at item 6 of the compilation, page 90. And the relevant portion is at para 40. I'm sorry, they're at para 19 at page 109. Where the CFR
Para
passage, para 19, I'm so sorry. 19 at page 109. And we always tend to cite the latter portion of this para, which is a court should iron out the creases but must not alter the material. But the earlier portion also is very interesting, and may I just show that to my lords at the bottom of page 109. My learned friends read a bit of it just now.
Yes.
The quotation is of Lord Denning: the English language is not an instrument of mathematical precision. Our literature would be much poorer if it were. He must set to work, that is the court, in the constructive task of finding the intention of Parliament. And he must do this not only from the language of the statute, but also from a consideration of the social conditions which gave rise to it and of the mischief which it was passed to remedy. And then he must supplement the written word so as to give force and life to the intention of the legislature. A judge should ask himself the question, how if the makers of the act had themselves come across this ruck in the texture of it, they would have straightened it out. He must then do as they would have done. A judge must not alter the material of which the act is woven, but he can and should iron out the creases. Now, please apply this squarely to our position. 34 is a recourse provision. And as my Lord Justice Vishwanathan put it to me, in fact, the substratum of 34 is to try and save an award rather than to nullify it or annul it. That is the material of section 34. All that it requires for your lordships to do is not even add words in, but interpret 34 as including the ironing out of this crease, that if you can, within the discipline of 34, modify the award by incorporating the correct position of law and obviously then consequential changes to the award, just by that, without reappreciation, would that not subserve the mischief which was intended to be remedied by the Arbitration Act, which is protracted litigation, cost, etc., and in fact subserve arbitration and subserve the Arbitration Act? Because the argument on the other side, with utmost respect to all my learned friends, does not subserve arbitration. It defeats it. It defeats the whole aim of arbitration to take such a rigid and inflexible approach. And I don't believe section 34 is not admitting of some play in the joints which your lordships cannot interpret.
Taking a cue from what you read out, Mr. Karnataka.
Yes, ma'am.
This is an issue which has been vexing this court at least since saw pipes in 2003.
I understand.
The Parliament had the occasion to amend this act twice,
Yes.
2016-19.
Yes.
We cannot presume that they were unaware of this problem,
No, of
which
course.
is vexing this
Of
court, vexing the very institution of arbitration. In spite of that, they have not made a change.
That is true.
This is something that Justice Nariman has touched upon in Hakim also.
That's it.
How do you get over that?
Yes. I would put it this way, that if your lordships are satisfied on an interpretation that the power exists in 34, then the fact that Parliament has not thought it fit to make an express provision would not alter that determination or interpretation of 34. It may be that the position would have been much clearer had they put in a separate subsection. But equally, they didn't put in a subsection on the Doctrine General.
Does it not convey the intention of the Parliament that there is no requirement for a change? They left it as it was despite being aware of the problems that
My lord is right.
was facing.
That is certainly a factor that your lordships can take into account to interpret 34. But on the other hand, if the plain language of 34 admits of a wider construction and interpretation, the fact that Parliament chose not to put in a specific provision should not alter that interpretation. That's my submission. And I'm sorry. Therefore, my respectful submission is either the fact that this was before Parliament or even the fact that the 1940 Act contains Section 15. I understand the solicitor. My lords have seen Section 15. I won't go through it again. But Section 15 is only the equivalent of existing sections under today's Act. So 15A is the separability provision of beyond the scope of reference. And B is imperfect in form or obvious errors. C is accidental slips or omission. 33 covers that. So 15 is not different in that sense from the position even today. And therefore I come.
If one goes by 15,
Yes,
A is obviously included.
is included.
It's
Even,
in perfect form, it is an obvious error which that's also included.
yes,
An award contains a clerical mistake or error arising from accident, slip or omission. This is obviously an implied power which every court has.
would always have. Would always have.
Because they suppose while writing the final part of the award, a figure mentioned omits 2 zeros.
Absolutely.
Or
That will
1
always be
zero.
part. That was always.
That will be, you can't say that the
33A covers it.
33A.
And 33A itself gives you the right even to go back to the tribunal if you would so wish. So 15 is really covered. There's no absence of 15. In fact, the acts are in paramateria and therefore the report.
And what was material at that time when we implemented the 1996 Act? Let's not forget. That was the occasion in 1990, liberalization has started.
Yes.
We were expecting foreign investment to take place. And normally arbitration is the method of dispute resolution resorted to in cross-border dispute.
Not. My lord.
That's a default mechanism. Court decisions are not default mechanism.
And finality. What the litigant wants is finality.
Whatever it is, but that's because every party invariably, when they want to invest or have a corroboration agreement, they insist on arbitration. Unlike courts being the default mechanism as far as internal disputes are concerned.
And unfortunately, many of them insist on a foreign-seated arbitration.
That's something separate. That's also changing.
That is changing, and the 2015 amendments, which ring-fenced international commercial arbitration, has gone a long way in ensuring that. Now, even foreign parties are more than happy to have India-seated arbitrations. And because of your lordships and other high courts, pro-arbitration.
So that's not
right.
That's not the issue.
That's not the issue. I'm not.
So what happens was we adopted the unilateral model.
Yes.
Which is basically framework also of the New York Convention.
Lordship.
More or less on that. We adopted that model and we just simply did it. But if one goes by that, normally we say we have to interpret the intent of the legislation. But while doing so, we have to be practical also, because legislation never meant that they will be impractical or something which is so obvious, which will be looked upon or can be overlooked by us.
My lord, if the intent is speed and finality, then fettering or making 34 rigid is contrary to that intent. So a purposive interpretation of 34 would only result if this limited discipline power modification is read into 34. Otherwise, it would be contrary to the intent.
There's another aspect. Yes, they have been, earlier the amendments were always very infrequent, very, very rarely done. Now, but the good thing which has happened is amendments have been taking place, whether it's the IBC Companies Act or for that matter, Arbitration Act, whenever they have found that there are problems. And if one goes by the latest amendment, which is a proposed amendment, we don't know whether it will be. There is a provision now dealing with modification.
Yes, now there is. But what happens in the interregnum is really.
We don't know.
We don't know what might happen.
We should not go into that case.
So I'm assuming that there's no express provision. My argument is based on that. But there's certainly an implied power of provision, and that can be read into the existing provision as well. And this would not be contrary to parliamentary intent. In fact, it would subserve the intention of the legislature.
And according to you, there is no prohibition also.
There's no prohibition, unlike Singapore, which has an express prohibition. Now, I am aided in this by the very fair submissions of the learned solicitor. My lords would kindly turn to his written submissions at page 137. para 174. In fact, para 172 at page 136. (172) at page 136. This is under the part that is headed Possible Ways of Reading in Power Modification. These are the Solicitor General submissions, the actual written submissions, not the compilation of the actual submission. Para 172. However, after referring to Hakim's judgment in 171, the learned solicitor submits, however, such literal and stringent interpretation of Section 34 of the 96 Act has posed many practical challenges. One recurring issue is regarding the calculation of interest, wherein the award suffers from no infirmity other than that of awarding an exorbitantly high or cut rate of interest. However, in absentia of provision regarding modification, the courts are left with limited remedy, i.e., either to set aside the award or remand the matter as per circumstances in subsection 4 of 34. Then he goes into the conflicting decisions. Page 174. After in 172 and 3, he sees the decisions of your lordships. In 174, he makes a submission. It is submitted that reading modification power into section 34 of the 96 Act is in furtherance of the object of the 96 Act. He's absolutely correct. It is settled principle that a statute must be construed to make it effective and workable. And then para 176 at page 138. Practically, the absence of a modification power leads to wasted judicial resources, as courts often have to set aside entire awards, even when a minor correction would suffice. This contradicts the pro-arbitration approach of minimal judicial interference and speedy dispute resolution. While it is accepted that courts should not rewrite awards or review merits, a narrowly tailored modification power limited to curable defects would align with the objectives of arbitration law while ensuring justice. But if gone, he then says this again ought to be appropriately dealt with by the legislature. But in para 174, he says even under 34, there is a modification power. So on objects, the learned solicitor has very fairly stated, speed, finality is the object.
In the beginning also he said that there are problems.
There are problems. He was very fair in making that submission. Now, that's the first basis on which I would submit your lordships can read in a power. But there is a completely independent basis as well, which I got to quickly go into. This is the basis of inherent powers of a court. A court hearing matters under the Arbitration Act, a special statute, would nevertheless retain the character, its own character as a civil court. The definition of civil court is in 2(1)(e). And that can sometimes be a district court, my Lord Justice Gawai gave the example, or it could be the High Court, depending on where you are. Because sometimes the High Court has original jurisdiction and therefore would be the district court for those areas. I'm going to deal with the two of them separately, if your lordships permit me. As far as High Courts are concerned, when they exercise the 34 power, they remain constitutional courts of record under Article 215 of the Constitution. No part of that power can be ceded or taken away, even by Section 5, which is a statute, even assuming Section 5 can be extended to the powers of the 34 court, that can't be taken away. Your lordships have held so in the context of Articles 226, 227, and other articles, that the High Court's constitutional powers conferred on it by 215, and in fact pre-existing as courts of record, cannot be taken away by Section 5. Just as your lordships, Article 142 powers cannot be taken away by Section 5. Because these are constitutional powers. Now, two judgments very briefly on this aspect of what is a court of record and what is its scope, ambit of its power. The first is in the celebrated Mirajkar case, Naresh Mirajkar. And that, my lord, will find in the additional compilation at item 9. At page 463. This is 1966 3 SCR, page 744. And if my lords are pleased to go to running page 486 of the compilation, para 59. Para 59, the running page 486 of the compilation. There is yet another aspect of this matter to which it is necessary to refer. The High Court is a superior court of record, and under Article 215 shall have all powers of such a court of record, including the power to punish contempt of itself. One distinguishing characteristic of such superior courts is that they are entitled.
Just 1 minute.
I'm sorry, running page 486 of the law. There is yet another aspect to which it is necessary to refer. The High Court is a superior court of record, and under Article 215 shall have all powers of such a court of record, including the power to punish for contempt of itself. Then the para goes on to say, such superior courts have the power to determine their own jurisdiction. And then about 2/3 of the way through the para, 10 lines from the bottom of the para, in support of this view, this court cited a passage from Halsbury's Laws of England, where it is observed that, quote, prima facie, no matter is deemed to be beyond the jurisdiction of a superior court unless it is expressly shown to be so, while nothing is within the jurisdiction of an inferior court unless it is expressly shown on the face of the proceedings that the particular matter is within the cognizance of the particular court. And then we go on to para 61 at page, it starts at the bottom of page 486, but the portion at page 487, the last 4 or 5 lines of para 61. Therefore, in our opinion, having regard to the fact that the impugned order has been passed by a superior court of record, in the exercise of its inherent powers, the question about existence of the said jurisdiction as well as validity or propriety of the order cannot be raised.
This will be a slightly truncated argument. That will be giving some specific powers to the constitutional court.
Constitutional court. So that would,
that may not be.
therefore, I'm making that slight distinction.
That power would be available only to the High Court and not to the.
That is true. That is true. Therefore, I say I'll deal with both separate. I'm going to deal with district courts.
This will be little more.
May I just place the point, my lord? There are several other paras which.
So if an arbitration arises in Thana,
It may have problem.
No, there is a remedy.
You'll have to section 38(4) bars.
No. I'll tell my lord why that doesn't help, because the second limb of the argument is that the CPC will apply there, and one will have 151.
No, you have already raised that argument. Don't stretch it.
Very well. Just one more judgment, my lord. M.M. Thomas. That is at page 527 of the compilation.
527.
527. This is a 2-judge bench. 2001 SCC 666. And if my lords kindly go to para 14 at page 533, there is a useful summation of the law there from paras 14 to 17. In para 14, your lordship says the High Court is a court of record as envisaged in Article 215 of the Constitution, must have inherent powers to correct the records. A court of record envelops all such powers whose acts and proceedings are to be enrolled in a perpetual memory and testimony. A court of record is undoubtedly a superior court, which is itself competent to determine the scope of its jurisdiction. Then page over, on the top of the page, they refer to the Mirajka judgment, then the passage from Halsbury, and then in parenthesis after the passage from Halsbury, the Supreme Court notes that though the references to English courts, the principle would squarely apply to superior courts in India also. And then 16, referring to the said passage and relying on the decision of this court in Naresh Mirajkar, a 2-judge bench of this court in M.B. Elizabeth has observed, quote, the high courts in India are superior courts of record. They have original and appellate jurisdiction. They have inherent and plenary powers, unless expressly or impliedly barred and subject to the appellate or discretionary jurisdiction of the Supreme Court. The high courts have unlimited jurisdiction. So if a high court is hearing a section 34, one cannot say it doesn't have the power to correct the record, because ultimately the award will be treated as a decree of the high court for execution purposes. One cannot say its inherent or plenary power to correct the record is taken away completely because of section 5 of the Arbitration Act. This is a power that pre-exists pre-Constitution, reaffirmed by Article 215 of the Constitution. And one other judgment of your lordships, in Jyoti Bhushan's case, item 12, page 550, slightly different point.
500 and?
550 of the compilation. This is in 1962 supplement 1 SCR, page 73. And the relevant para is paragraph 9, which starts at page 553. But may I go straight to page 554 to save your lordship's time and read the last portion of para 9 at page 554. After the extracted portion on the top of 554, there is a paragraph starting with counsel for the appellants. About halfway through that paragraph, after referring to the Privy Council decision, the sentence starting with the jurisdiction to deal with the claims of companies ordered to be wound up is conferred by the Indian Companies Act, and to that extent the letters patent are modified. There is, however, no difference in the character of the original civil jurisdiction which is conferred upon the High Court by letters patent and the jurisdiction conferred by special acts. When in exercise of its authority conferred by a special statute, the High Court in an application presented to it as a court of first instance declared its liability to pay a debt, the jurisdiction exercised is original and civil, and if the exercise of that jurisdiction does not depend upon any preliminary step, invoking exercise of discretion of the High Court, the jurisdiction is ordinary. So even under the Arbitration Act under 34, it is the ordinary original civil jurisdiction which is plenary in its scope.
That's Hemji or Grindley's.
Now, my lord, as far as
Just
other courts are concerned, I'll be very brief. I have 2 or 3 judgments and points and I'll be done. In ITI Limited and Siemens, which your lordships will find at page 717 of this very compilation, two judges of this honorable court. The citation is 2002 5 SCC 510. And at para 13, which is at running page 724 of the compilation, the court negatived the argument based on section 5. And I quote, "We also do not find much force in the argument of counsel for the appellant based on section 5 of the Act. It is to be noted that it is under this part, namely part 1 of the Act, that section 37(1) of the Act is found, which provides for an appeal to a civil court. The term court referred to in the provision is defined under section 2E of the Act. From the said definition, it is clear that the appeal is not to any designated person, but to a civil court. In such a situation, the proceedings before such court will have to be controlled by the provisions of the code, and therefore the remedy by way of revision under section 115 of the code will not amount to a judicial intervention not provided for by part 1 of the Act. To put it in other words, when the Act under section 37 provided for an appeal to the civil court and the application of the code not having been expressly barred, the revisional jurisdiction of the High Court gets attracted. If that be so, the bar under section 5 will not be attracted because conferment of appellate power on the civil court in part 1 of the Act attracts the provisions of the code also. Now, as I pointed out, the next judgment at page 728 in MTNL, also of 2 judges, says we are bound by ITI, but we disagree with the statement of law. We find the statement erroneous and they referred it to a larger bench. That is in 2017 2 SCC page 37. But that reference is still pending. To the best of my knowledge, subject.
which is the paragraph 11?
Paragraph 11. In MTNL para 27, I'm sorry, para 27. At running page 741, the last page of the judgment. And they do so on the footing that they say the Arbitration Act is a complete code. Now, if ITI is correct, then the CPC applies, which includes 151. So all courts, including district courts, will have that power. The necessity is for your lordships to define what that power is and to ensure that it's strict and disciplined within 34. That itself will be enough. Number note, one last judgment of your lordships, which I must place before my lords, is the bench of 7 judges in the Stamp Act matter. That is item 13, page 556 of this compilation. I want to just read 4 paragraphs, 4 short paragraphs from this judgment. This is reported in 2024, 6 SCC, page 1. The first para is para 67 at page 627. At 627, para 67, your lordships hold. Arbitration is a method of alternate dispute resolution where parties agree to refer their disputes to a neutral third party known as an arbitrator. Running page 627 of the compilation. I'm so sorry. Para 67. Arbitration is a method of alternative dispute resolution where parties agree to refer their disputes to a neutral third party known as an arbitrator. The aim of arbitration is to provide speedy, efficient, and binding resolution of disputes that have arisen between the parties in regard to their substantive obligations. The thrust of arbitration law is succinctly encapsulated in Redfern and Hunter. It is to be expeditious where the law is slow, cheap where the law is costly, simple where the law is technical, a peacemaker instead of a stirrer of strife. Relegating a successful party to a new round of arbitration, stirrer up of strife. It cannot be in consonance with the objects of this act. Then if my lords see para 81 at page 631. This is a little important because my lords have interpreted section 5 and given its correct scope and meaning. In para 80, section 5 is set out. But then if we go to 81 at page 631 of the compilation, what your lordships have held is this. One of the main objectives of the Arbitration Act is to minimize the supervisory role of courts in the arbitral process. Party autonomy and settlement of disputes by an arbitral tribunal are the hallmarks of arbitration law. Section 5 gives effect to the true intention of the parties to have their disputes resolved through arbitration in a quick, efficient, and effective manner by minimizing judicial interference in the arbitral proceedings. Parliament enacted Section 5 to minimize the supervisory role of courts in the arbitral process to the bare minimum and only to the extent so provided under Part 1. In doing so, the next sentence is very critical. In doing so, the legislature did not altogether exclude the role of courts or judicial authorities in arbitral proceedings, but limited it to circumstances where the support of judicial authorities is required for the successful implementation and enforcement of the arbitral process. Therefore, an interpretation of 34 that supports the arbitral process, supports the aims of finality and speed, is not contradictory to section 5 at all. And then one more para.
But subject to what Mr. Banerjee and Mr. Kripal may say, you may
Yes.
also consider this.
Yes, ma'am.
Instead of this bifurcation between high courts and civil courts.
Yes, ma'am.
See, section 5, if it is to be construed as a bar, this court, even in the context of a constitutional bar in 329,
Yes,
has said that anything in furtherance of the object
precisely.
will not be impeded. If it is to frustrate, yes, we will invoke the bar. So section 5 will not come in the way of any interpretation which furthers the object of the act. In a way, what 81 says, if you have support in the constitutional context,
I'm truly
of
obliged.
course,
That is
subject to what they
that
say,
is precisely what the seventh
Not be read
judge
as-
said in para 81.
then the last words, unless provided in the act, will be read to mean that 34 implies this power. This is of course subject to what they say.
Lordship. 81 clearly holds this in interpreting section 5. One more paragraph, 84, at the bottom of page 632 of the compilation. After setting out the non-obstante clause, which section 5 starts with, para 84, what your lordships say is, although a non-obstante clause must be allowed to operate with full vigor, its effect is limited to the extent intended by the legislature. In ICICI Bank and Citco Leathers, a 2-judge bench of this court held that a non-obstante clause must be interpreted by confining it to the legislative policy. Thus, even if a non-obstante clause has wide amplitude, the extent of its impact has to be measured in view of the legislative intention and legislative policy. In view of this settled legal position, the issue that arises for our consideration is the scope of the non-obstante contained in Section 5. And then the judgment in Morgan Securities is also cited. And the last line of para 85 says, in other words, the scope of the non-obstante clause is limited to prohibiting the intervention of judicial authorities unless it has been expressly provided for under Part 1 of the Arbitration Act. So, judicial intervention, if in support of the aims and objects and legislative policy, is not proscribed by Section 5 at all, because that would turn it on its head. Section 5 can't be used as an instrument to destroy the objects of the Arbitration Act, which is speed and finality, and which it would be if it is used as a fetter on Section 34, power of modification in certain limited and extenuating circumstances, to prevent a miscarriage of justice, to correct a patent error of law, the correction of which alone turns the award. Take my own case. I know my laws are not going to facts, but as an example, the three applicants, one is an 82-year-old widow who's been out of her home now for almost over 20 years, and her two sons. The award, the tribunal, we succeed completely on an agreement that is entered into, specific performance, our right to get our alternative accommodation, which was promised to us under that contract, readiness and willingness, everything the tribunal upholds. But then it says in one pithy paragraph, and I'm not obviously in challenge before your lordship, that these three are fiduciaries of the company with which they entered into the contract, ignoring the fact that the mother was not even a director of that company, but of some other subsidiary or associate company. One of the sons was not a director. One son was a director, but admittedly did not participate, and under Section 88 of the Trust Act, did not avail himself of his character. But it's like, too bad. Therefore, this contract is bad unless approved by the shareholder. Just in one sentence, contrary to a lot of judgments that we cited. Now, that's patently an error of law on the face of the award. The dissenting judgment, in fact, decides again everything in our favor. On this point, says no question. 88 has no application. And these are not fiduciaries. Ex specie, a non-director can't be a fiduciary unless there's some other capacity pleaded, which in this case there's not. Now, in such a case, if the 34 court feels that that 2 or 3 sentence unreasoned finding on law is patently erroneous, and the correct law is that they are not fiduciaries, and 88 does not apply, then surely it should be permitted to incorporate that into the award, and with consequential changes, that's the end of the matter. If I succeed in 34, the matter is still pending, the best result I can get is restart the whole arbitration. 82-year-old widow has to restart a whole arbitration with evidence, trial, etc. Now, I've just prepared a one-page note, if your lordships, on the facts of my case. I've already summarized them, so I don't want to read it again.
No, facts of the case, to be very frank, will not be.
But as an example, only as an example. Now, my lord, therefore, I come to the final part of my... So just
Because
one...
throughout there is an intervener gotten, but we don't even know whether the other side is here or not.
Wait, I'm not asking my lord to go into facts. I'm arguing it only as
But
an
you
example.
can say not facts of your case in a given.
In a given case, I appreciate that. No? In a given case, this could happen. I gave another example of limitation that is equally unfair and harsh. And to decide that an award is vitiated by patent illegality, of necessity, the 34 court would have to say and determine what the correct position of law is. So there's no extra determination being done there. Therefore, that approach would end a dispute rather than perpetuate it for generations. I mean, I just refer to it, I won't cite it, in Deep Industries, which is also set out in page 535 of this compilation, 2020-15 SCC 706, para 17, my lords have held, constitutional powers can't be taken away by Section 5 of the Arbitration Act. Therefore, I come now to the summation. I commend to your lordships to follow, in part at least, the procedure and law in England. In England, there is an express variation power. Let us be very clear about it from the beginning. But it's couched in general terms, power to vary the award. That's all it says. But English courts and English commentators have narrowed that power And the best enunciation of that narrowing of the power is found in Mustill and Boyd, which my lords will find at page 260. Just one sentence of this compilation. At 261, varying the award, just one sentence. The heading starts varying the award. First sentence is an order varying the award will not necessarily result as a matter of
From what?
Mustill and Boyd, second edition,
Okay.
page 261. Order varying the award will not necessarily result as a matter of course from a successful appeal. We suggest that such an order will only be appropriate where the variation, including any variation of the award on costs, follows inevitably from the court's determination of the question of law. So it must then be obvious. It doesn't require a revisitation, reappraisal, a redetermination of anything. And English courts have held, including the judgment in Fencegate at page 265 of the compilation, that even this wide power of variation is restricted to the two essential requirements. And I'll just state them for my lords. One is, it must not involve a fact-finding exercise. You must take the arbitral records as you find it. No variation, reappreciation of facts. And the second is this: the variation must flow inevitably from the court's determination of law. Yeah, I've said that. I'm not reading it, my lords. It's in my written submissions. I've referred to it. Therefore, if we apply a similar principle to 34, what is the discipline of 34? The discipline of 34 is it's not an appeal. One cannot reappreciate evidence. One cannot go into merits. That is an express prohibition in 34. However, if any part of the award is vitiated by a patent illegality, that part can be severed if the conditions exist and set aside. The only interpretation would be that instead of stopping at merely cutting off the objectionable portion, if the objectionable portion can be substituted by an inevitable position of law which flows from that patent illegality, then that should be done. And then obviously whatever consequential changes are required to the award, only out of that question of law.
This may sometimes lead to a lot of issues and problems. The courts may sometimes interpret it, how it can be segregated, what cannot be segregated. Itself can become a huge issue in many cases.
My lord is right, which is why I
That may
respectfully...
itself have the effect of delay.
My lord is right. My lord is absolutely right. In fact, I am equally concerned
Because
about
the
opening of a complete
ingenuity
flood.
on your part quite apparent to us.
My lord, I'll tell my lord, if my lords issue directions under Article 142, now my lords have already done that in the context of arbitrators' fees in the AFCON's case, which is also part of this compilation. It's not limited to fundamental rights as the learned solicitor said. If my lords limit that power which is interpreted only to a situation either of complete miscarriage of justice or where the question of law, if reversed, will inevitably lead to a different position,
You see,
that would be sufficient protection in my
that
respect.
day I gave you the example of a counterclaim
Yes.
wherein penalty has been allowed. The court may say, okay, you all know what is the range. Let's fix a reasonable amount and
Gotcha.
finish it off. They will. Now, somebody may say court can do that. Court can do that. In your case, probably the facts, or the given case, the facts may be such, but where do we then draw the line? Mr. Dattar suggested curable defects.
My lord
Which
is
are
right.
curable,
What I am commending is, if my lords say that,
which cannot be cured.
may I suggest one more thing? My argument does not extend to the head of public policy because that is a far grayer area. So international commercial arbitration will be in any case ring fence.
No.
It will not.
The difficulty in accepting that argument is it will apply across the board to 34.
Only to patent illegality.
No, that may not be correct.
If the test that I'm suggesting
That may not.
of where it inevitably flows from a
It's
determination
not,
of the
we
correct.
cannot visualize all the circumstances.
My suggestion is, my lord, if it's restricted to patent illegality, because it inevitably flows. Public policy is too gray an area to say what is the correct public policy, what is not. But if it inevitably flows, then it subserves the object of finality and speed.
Public policy.
Yes. Explanation 1
Yes.
under 34(2)(b). Public policy would go to the extent of covering anything that is in conflict with the most basic notions of morality or justice. That is throwing the
That is
case
right. I'm
wide.
not, therefore I'm not commending that. My lord is absolutely correct. Therefore I made pains to say, I'm not saying the approach I'm commending will cover public policy issues. Only questions of patent illegality, which my lords will of course find in subsection 2A, a separate subsection to 34.
So interest can't be touched because it may arise in an international commercial arbitration award.
Because it would be patent illegality. It might not. But all such questions arising in domestic arbitrations where there's a patent illegality, not a public policy issue, is what I suggest the court gives consideration to. Given the extent of the problem and the hardship, we appeal to your lordships to then, this is the solution we have to offer, which I think if your lordship passes guidelines under Article 142, it can be contained. I'm deeply grateful, my lord, for the time that has been sufficient.
Only one line on it.
My lord, may I?
What can be subject matter of severance? Section cannot.
I'm not asking for that.
The last part was, it don't apply it to the last, 2A, apply it to others. So section.
No,
is not
my learned friend has misunderstood. I said, my test that it must inevitably flow cannot be applied to public policy because it won't inevitably flow. It can only apply to a question of law.
No, if we accept that argument, it will defeat the earlier arguments. It's contrary to that, because the earlier argument was relying upon different concepts, whether it was a constitutional power, inherent power,
Right?
or subsumed power.
My lord is right. Therefore, I
So if we
started by,
accept that argument,
I said,
then this is contrary to that.
I said,
That it will be there, but it will not apply to.
may I clarify, my lord? I don't want to be.
Maximum, you can say public policy, it will not apply, because
Or to
that's a
prevent
implied
abuse,
power.
miscarriage of justice. I've also added that. I've not said a miscarriage of justice case can't be modified. That also.
This you
That
can
and-
take with yourself.
Yes, may I be permitted to put in a short supplemental submission because some of the judgments I put in my original submissions are not there, the ones I've cited. May I be just within a day or two, by tomorrow I'll file. Only what I've argued, nothing more. Very deeply grateful.
In 2 pages.
Not more than two.
It's not such a.
Not more than 2 pages. I bow to that. Very grateful.
May I appear? I appear in item number 501.2 for the petitioner. And in my submissions, I had cited certain judgments, some of which have been taken care of by the previous council, my lord. But I'll be to the point. And your lordship may kindly appreciate my submissions in 3 broad heads, my lord. First is the legislative intent as regards modification. Second is the contours of the power for
What is
modification.
your name, counsel?
And the main council, my lords.
What is your name?
Vaibhav Dang, my lord.
Sorry?
Vaibhav Dang.
Vaibhav?
Dang. And third point, which I will be making, my lords, is with regard to the requirement for the looking into in the judgment of the Hakim, my lords. My lords may kindly have the Bail Act itself. And my first submission is that the legislature is not averse to the modification, rather the intent of the legislature, as we can gather from the act itself, is in favor of the modification. And for that, your lordship may kindly have section 8B of the act, my lords. Your lordship have it?
Yeah.
Power of the court seized of matters under section 34 or 37 of the act to refer the dispute to mediation or conciliation. 1. If during the pendency of a petition under section 34 or an appeal under section 37 of the Act, it appears to the court that there exists element of a settlement which may be acceptable to the parties, the court may, with the consent of the parties, refer the parties for resolution of their disputes to mediation or
But
conciliation.
this is applicable to the Union Territory of Jammu Kashmir.
Pardon me, lords?
This is applicable to Union Territory of Jammu Kashmir.
But that is where the indication for the intent is. If it is applicable for the UT of the J&K as well as the Ladakh, my lords, by the order in 2020 which the parliament had passed, then it shows that the parliament is not averse to the modification per se.
This was a state amendment.
State amendment, my lord, only with regard, but done by the parliament. It has been done by the government itself, my lords, union government. It's now a UT.
It has been done only insofar as Union Territory of.
That-
Only with
That
regard.
apart, let's be very clear. That apart, let's be very clear. Even if there is an award,
My lords.
the parties enter into a settlement, the parties can by agreement get over the award.
But kindly have the 8
Because
H.
Because that's even with regard to a court degree that applies.
No, kindly have 8B2H for a moment.
Aspect. The parliament was exercising powers of the legislature in view of, my lord, the precedents rule. So it is a state amendment.
It's still done by the parliament in my respectful submission, my lord.
It is, yes, it's done by parliament
Still, my lord.
as
For the state.
legislature of the state.
And kindly have, my lord, this subclause H, my lord. Such a mediated settlement shall have the status of a modified arbitral award.
That's even true even in the conciliation provisions of this act, which we have never resorted to, which we have never.
So submission over here is, there is an award passed by the arbitrator. When the proceedings are pending before the court under section 34 or under section 37, and the court with the consent of the parties refers the parties to
Okay,
mediation,
we have understood this argument.
then the award itself can be modified, and that modified award will be the one which will be enforced under law. So the parliament is not per se averse to the modification. That's my one submission, my lord. But so far as the contours of modification, in addition to what has already been argued, my lord, my respectful submission is, my lord, kindly have my written submissions. And I have given 3 instances in which the modification,
Where is your submission?
I have given the hard copies.
Yes.
Now kindly have page 3 of my submissions, my lord. Para 7(4), my lord, Roman. This I will refer in context of the Hakim also, but still kindly have these 3 situations which I have envisaged. My lord, one is the mutual consent of the parties. My lord, as I was referring to 8B also, if the parties during the pendency of the proceedings my lord, has it? My lord, has, my lord. My lord, the first suggestion which I have is, my lord, in the circumstances, my lord, the first is the mutual consent of the parties. My lord, if during the pendency of the proceeding before the court, both sides request the court, my lord, either to go for mediation or otherwise, that they have decided to end their dispute in a manner which is otherwise done by way of the award, my lord, what the award says, then there is no embargo against that, my lord. Court can put its stand for approval over there. And that would also amount to a modification of the award itself. Because the arbitrator, what the award he has passed, not, it will not be then that award which will be enforceable, it will be then the modified award. The second situation, my lord, is is to correct the error or interpret a specific point or part of the award as per section 33, 1A and B of the Act. But what the arbitrator can do under section 33, my lord, to a limited extent, my lord, that the court can also do it when the proceedings are pending, my lord. But what so happened in my case, my lord, I'll just briefly refer, and in a given case, it can be taken as an example, that in this case, what happened was that the original contract value was reduced during the pendency of the contract, my lord. The arbitrator awarded the sum on the original contract value toward the overhead charges. Now, when the matter traveled to 34 court, my lord, the court said, no, there is a fundamental breach on the part of the department. You are entitled to the overheads. There is no dispute to that, but not on the original contract value, but on the reduced value of the contract. But the court did not give me that because the court found that the award cannot be modified to that extent. Now, I went in 37. The 37 court also upheld the same position, that you are right in saying there is a fundamental breach. You are right in claiming the overhead. Your entitlement for the overhead is also justified. But we can't give you that because that would amount to modification. So what was required to be done was, instead of looking at figure A, the court was only required to substitute the figure A by figure B. But the court did not do, because the court said that would amount to a modification of the award. Now, for that very reason, a fresh arbitration will have to be undertaken. So my submission is, if only a correction of the amount, which the arbitrator also could have done under 33, can substitute and replace the figure, and the ultimate outcome can be maintained, because there is no dispute by the department with regard to the amount as such. If that can be maintained, there was nothing preventing the court from doing that. The court would have very well done that. Now, the third submission is with regard to is the circumstance where the court, to ensure parity, especially while dealing with the cases involving the payment of compensation under the Act such as the National Highways Act. Now, here is an example over here for this, my lord. Kindly have the judgment which I have filed along with this very compilation. The third judgment, lord, of Abdul Ismail Said, Division Bench of the Madras High Court, my lords. Well, first scenario under Order 23, my lord. Principles, my lord. No, my lord, my submission is, my lord, if we look at in the context of section 8B, then it is supported over there also. Basically, when the court is even referring the parties to mediation, it is acting with the consent of the parties. When the consent is there in the first scenario which I proposed, consent is there, modification can be done whether it is done through mediation, conciliation, or the parties otherwise approach the court with a settlement, which the court will independently look into. 8B very clearly says, once the mediation settlement is sent back to the court will judicially look into it and pass appropriate orders. That is what the language of 8B is specifically. So when the court is passing an order, and then order is then a modified award enforceable under section 33, it encompasses all the situations where the award can be modified. Now, in this very judgment, my lords, Abdul Ismail Said, lordship may kindly have para 59.
Page number?
Page number, my lord, 108. Para 59 starts at 107, bottom. I'll be reading from 108, my lords. 7th line from the top, my lords. Now, this was a live case, my lord, where the Honorable Court Division Bench of the Madras High Court, my lord, looked into Western Gecko judgment also, 3 judges case, and it upheld the modification, my lord. Mary, my lords, page 108, 7th line.
Lord, I just wanted to point out, Western Gecko is pre-2015. The ratio in Western Gecko has been legislatively overruled as recognized in Sanyong. So I just wanted to point that out on Western Gecko.
Yes, please.
7th line from the top at page 108, my lord. Even in cases, my lords have it?
Yes.
Even in cases where award of the district collector is set aside. Now, my lord, what happens is under the National Highways Act, section 3, my lord, the arbitrator is given under the statute, which is the district collector, my lord. My lord, district collector, then either party can go for the reference, my lord. He passes an award and then the decision comes, my lord. Now, the subject matter of this case was that only. The Honorable Division Bench said even in cases where the award of the district collector is set aside and remitted, there is no guarantee for getting compensation with an application of judicial mind. As a result, the landowner may spend enormous time in courts with no hope. Unless the provisions of Arbitration and Conciliation Act, which has now been incorporated into the NH Act, are interpreted to remedy the situation, following the judgment of Honorable Supreme Court in ONGC versus Western Gecko, which we consider to be fair, at least while interpreting Section 34 as applicable to the NH Act. Otherwise, there will be grave injustice to a section of people whose lands were acquired under the NH Act. When Honorable Supreme Court in Tarsem Singh's case Supra has declared that provisions of Land Acquisition Act relating to solatium interest contained in Section 23(1)(a) and interest in terms of proviso Section 28 will apply to acquisition made under the NH Act, and that Section 3J is violative of Article 14 of the Constitution, the court is of the view that in the same spirit, the provisions of the Arbitration and Conciliation Act, which have now been incorporated into the NH Act, have to be interpreted for the purpose of determining the compensation, bearing it in mind to save the Act otherwise being unconstitutional and violative of Article 14 of the Constitution. Para 60. When the Honorable Supreme Court in several judgments, including the judgment in M. Hakim's case, have uniformly observed in every case that they do not intend to interfere with the judgment of the High Court, even where the award of the collector had been modified by court for doing complete justice, the inference that can be drawn is that power to modify the award is necessary to render justice, for which we constitutional courts are meant for. Learned amicus curiae in this case has relied upon a few judgments of Honorable Supreme Court, where courts have interfered with the award on merits by modifying the award, even though there is no discussion or issue being raised therein, whether the courts have power to modify the award. Maybe all those judgments relied upon by the learned amicus curiae need not be cited as a precedent, as distinguished in M. Hakim's case Supra, but the power of court to modify the award should be made available when it is applicable to challenge the award under the NH Act, in larger interest of public to render justice and to ensure the constitutional guarantee to which every citizen is entitled to. Para 61 minutes. The learned counsel appearing for the third respondent produced before the court judgment of learned single judge of this court in the case of Project Director NHAI versus R. Jayakumar, so and so. It is a case where the NHAI filed the appeals as against the order of the Principal District Judge, Salem, in so and so under Section 34 of the Arbitration and Conciliation Act. The learned Principal District Judge, Salem, though confirmed the award passed by the arbitrator, District Collector, on the quantum of compensation, directed the NHAI to pay 12% interest on the market value from the date of modification of the to the date of the award, and also directed to pay 30% of the award amount towards solatium. It is to be noted that the order of the Principal District Judge is in accordance with the judgment of the Honorable Supreme Court in Tarsem Singh's case. Messrs. NHAI challenged the order of the Principal District Court mainly on the ground that the court has no power to modify the award in a petition under Section 34 of the Act, and that therefore awarding interest which is in the nature of modification of the award is impermissible. The learned single judge relied upon the judgment of the Honorable Supreme Court in M. Hakim's case, placing reliance on para 39 to 58 of the judgment in M. Hakim case. The learned single judge held that the district judge ought not to have modified the arbitral award passed by the district collector and set aside the impugned order passed by the principal district judge in so and so, even though interest in some terms of Section 23(1)(a) and solatium at 30% are now payable as per the judgment of the Honorable Supreme Court. In Tarsem Singh's case, the learned single judge set aside the order of the Principal District Court. The judgment of the learned single judge shows that the landowner is denied the relief which he is entitled to as per the judgment of the Honorable Supreme Court. Since the interpretation of statute should be purposive and taking into account the possible mischief or prejudice that is likely to be caused to the landowners, this court is of the view that Section 34, when it is applied to the NH Act, the power of court to modify the award should be read into in public interest. Having regard to the long discussion of several judgments examined by this court is inclined to follow the judgment of three-member bench of this Honorable Supreme Court in ONGC versus Western Gecko, upholding the power of the court to modify the award particularly when the unamended provision under Section 34 of the Arbitration and Conciliation Act is incorporated into the NH Act, subject to the provisions of the NH Act, my lord. So the courts have, my lord, read into this power by following the three-judge bench decision. Now, my lord, the next point which I'm making, my lord, is with regard to the Article 142 power, my lord. Now, as you should know, my lord, that power is exercised to do complete justice.
No, that we will not go into.
Now, my only humble submission is
We'll
that,
go into that.
when that power is exercised to do justice, what it means is, as per decision of this Honorable Court, my lord, Constitution Bench in Supreme Court Bar Association, my lord, the court, while exercising that power, will not do anything which is against the intent of the statute to do something indirectly, which is directly prohibited. So my summation is, when that power is exercised and the court is doing something which is not barred under the statute, obviously the same can be done by the civil courts also by exercising the power under Section 151 of the CPC, if the provisions of CPC are read into the statute, my lord. That's my summation on that point, my lord. Thirdly, my lord, is on the aspect of the decision in the case of my lord M. Hakim, my lord. And my submissions over there, my lord, is with regard to that it requires reconsideration, because that was passed in the context of the NH Act only, my lord. It was not passed in a matter which was not dealing with any other statute, in the sense that broader Arbitration and Conciliation Act. The court was seized of the matter in the context of the NH Act. Under the NH Act, Section 3, my lord, there is a district collector who is acting as the arbitrator, my lord. Now, I have filed the memorandum also on record issued by the government. The district collector is paid a very nominal fee, my lord. He is paid, as per revised schedule, my lord, 500 rupees for 1 day hearing, my lord, subject to maximum of 10,000 rupees, my lord. That is his entire fees for the arbitration, whichever party goes to invoke the arbitration, my lord. As against that, my lord, if the private party goes in and invokes the arbitration, 4th schedule at least applies, my lord, where the burden of the cause in the event of a re-arbitration will be much more when the party having spent considerable amount of time as well as resources in the previous round of the arbitration and in the subsequent litigation up to whichever court, my lord, the matter may have traveled to. Now, if the parties are then sent back to reinitiate the arbitration, the aspect of the cost element, my lord, and the financial burden that will be caused on the party as a result, therefore, my lord, has not been considered in the case of the N. Hakim, my lords. That's one submission, my lord. And the office memorandum is already there on record, which shows what amount is being payable. And this office memorandum, my lord, came up before the Honorable Division Bench of the Punjab and Haryana High Court, of which Justice Masih was part, my lord. I filed that judgment also on record, my lord, as a consideration where the arbitrator went ahead and charged a fees, my lord, which was over and above the office memorandum. The Honorable Division Bench in that case said, my lord, it is completely illegal. You have to go only by the nominal fee. So when in that case, my lord, under the NH Act, there is a fixed amount of fee, and still the court is saying that remanding the parties back for re-arbitration, my lord, is not workable.
Why do you say that? The 3G7, which is expected in Hakim,
Right, my lords.
expands the power of an arbitrator under the NHA Act, gives the arbitrator power to determine market value under 3A.
Well, the court, my lord, in this case, my lord, ultimately upheld the fact that the submission is, my lord, with regard to whether it was a consensual arbitration or a non-consensual arbitration. That was one of the aspects the court was seized with. The court said, irrespective of that position, the Act provides with regard to a forum to be there for the adjudication. You have to go with to that forum. Even in case of a modification, the court cannot do the modification.
No, just in 3G7, in Hakim Para 12.
Para 12, my lords. Just
There seems to be an expansion of the power of the arbitrator
3G, my lords, Para 12.
in Hakim page 13.
Section 3G, my lord.
3G.
3G.
Subsection, see, first it goes to competent authority,
My
then
lord.
it goes to central government, then it goes to arbitration. Now, 6 says Act will apply, 7, just read 7.
The competent authority or the arbitrator,
Or the arbitrator. Now read.
while determining the amount under subsection 1 or subsection 5, as the case may be, shall take into consideration the market value of the land on the date of publication of the notification. Under
It's a redetermination done like the reference code.
No, my lord, my submission over here is, my lord, the
Yeah,
arbitrator,
that is understanding.
the competent authority or the arbitrator, my lord, when the matter goes to them, my lord, do not decide on the basis of the market value of the land and still passes an award. What is the recourse available against that? The only recourse as per the scheme of the Act is Section 34.
Post this stage, you are saying.
Post this stage, my lord. And we are also concerned with the post stage of the award. When the award is already there, be it passed by the competent authority under the NH Act or the arbitrator under the NH Act or under any other contractual matter relating to a constructor or a builder. When a stage of award has already passed and the matter has been decided one way or the other, now who is to then remedy it? So the Honorable Court, my lord, in this case, my lord, holds that you have to go back to the arbitrator because he is the person. But the cost element which is involved in all other private arbitration, including the institutional and the international commercial arbitration, re-invocation of the arbitration, my lord, that aspect has not been considered over here. Under the statutory arbitration, where the official is a government official bound by the official memorandums of the government, where the amount is fixed, not more than 10,000, 20,000 rupees in certain cases. The re-invocation of the arbitration, at least on the cost element, can be considered as not onerous to the parties, my lord. Here in the cases of the private arbitrations, when we have to go back, now arbitrators normally in all the matters, my lord, they don't normally give the actual cost incurred by the parties. What they give is the notional cost, even with regard to the fees also, my lord. When the parties go back for the arbitration, they have to incur the entire fees and the expenses with regard to the arbitrator, with regard to the lawyer's fee, and then wait for the final adjudication of that award also through the process of the court. That entire process, my lord, is a cost.
It's already argued by Mr. Kambata and Mr. Datta.
No, that's what I'm not insisting on that point. I'm just simply referring to it in this context, my lord, that Hakim did not consider the aspect with regard to the cost element on the process of re-arbitration, my lord. That's what one point is, my lord. And my lord, one judgment, my lord, which I cited in the compilation, my lord, the second compilation which I filed, my lord. It's the Alpine Housing Development, the second volume, my lord. Just briefly, my lord, with regard to the applicability of the provisions of the code, my lord. Though Mr. Kambata has argued on that, my lord, with regard to the inherent powers. And it was also indicated before this honorable court that the judgment in the ITI Siemens has been doubted by the division bench in the subsequent case. My lordship may kindly have this judgment of Alpine Housing Development. Division bench of the Karnataka High Court, my lord. Just a few passages. Page 81, my lords. The last 8 lines. It was in the context of the Consumer Protection Act and the applicability of the CPC over there. And the Honorable Division Bench says, a perusal of the lordship have it, not? Lordship have? A perusal of the entire Consumer Protection Act 1986 would disclose that the provisions of the Code of Civil Procedure 1908 have not been excluded. Generally speaking, the Code of Civil Procedure only codifies in one code what may generally be viewed as the general principles of law concerning the procedure which we are concerned to be handmaid to justice. If the Commission had the power to set up ex parte any person before it, while it is still seized of the dispute, it would also have the inherent power to also recall or reverse such an order, or also restore the complaint on good cause being shown if it is dismissed for default. Well, the issue over here was dismissal in default. But my summation is, if the provisions of the CPC are generally being adopted by the court while dealing with the cases under section 34, surely 151 CPC is also available to the court, because the court, when it sees of the petition under section 34 or 37, issues the notices for which the CPC is followed, dismisses the petition in default for which the CPC is also followed.
That's all?
That's all, my lord.
Okay, now how many? You are Mr. Rai, you are there?
Yes.
How much time will you take, Mr. Rai?
But I'll take 15 minutes. I've in fact prepared a new 3-page note.
Okay, others may then confide. Okay.
Because on the specific aspect of 34.4, which fell from Justice Vishwanathan, I can just take 10 minutes whenever my last permit.
34.
First, it just have a solution, I'm saying.
Okay, just sit among yourselves and then decide who's going to begin. Give a slip of papers to everybody. We'll call out the names by slip of papers.
Obliged.
The court master will call out your names, call out names and then we start. I don't want everybody to be coming up and sitting up at the same time. Yes, Mr. Rai.
Lord, I've prepared, I've already filed a written note, but I've prepared a new 3-page note so that I don't, my Lord, overlap with submissions your lordships have already heard. And my Lord, attempt to address the questions that your lordships was posing even last week, my Lord. May I hand up that 3-page submission, my Lord?
Please.
Yes. I've, my Lord, tried to make it in 2 parts, my Lord. 1A, the basis for the power to modify an award in proceedings under Section 34, and 2, the guardrails, which may define the scope of that power. Because, my Lord, one aspect that has been highlighted is that when parties decide to arbitrate, they are looking for an expeditious, a cost-effective final resolution of their dispute. That is, my Lord, one overarching consideration, my Lord, which would weigh with us as we seek to interpret.
It all argued by Mr. Dattar
Yes.
as well as Mr. Kambata also.
Yes. I was, my Lord, adding one aspect to it also, my Lord, which is that an arbitration agreement is also a decision actively taken by the parties that their dispute will be decided by arbitrators. It is, my Lord, in that sense, opting out of a civil court and leaving the matter to an arbitral tribunal. These are, my Lord, in my respectful submission, the tensions that weigh when your lordship will decide the guardrails of this modification. That is to say, my Lord, the guardrails may not extend, and that's what I'll try and, my Lord, develop, to the point where, my Lord, the court is making a decision which the parties had otherwise felt the arbitral tribunal ought to make. My Lord, once an arbitral tribunal delivers an award, then, my Lord, it becomes functus officio, except for the powers contained in Section 33. That is, my Lord, the powers to correct clerical errors, and also, my Lord, when an arbitral tribunal has not determined certain issues.
But if the matter is remitted under subsection 4 of Section 34.
I'm sorry, my Lord?
The matter is
Yes.
remitted
I was coming to that,
under
yes.
subsection 4.
Yes, it is, my Lord, the rule is, my Lord, it is functus officio except for Section 33 and the power under 34(4). Those are, my Lord, the 2. But otherwise, my Lord, as a normal rule, the moment the tribunal delivers its award, my Lord, it becomes functus officio. And, my Lord, a party will have recourse to Section 34 in respect of that award. My Lord, I've tried to make this point at paragraph 2. The term recourse used in 34(1) is wide and includes the power to modify, vary, or set aside a part or a whole of the award. This is what, my Lord, has already been argued. My Lord, Iyer defines recourse as being the act of seeking help or advice, method of enforcement of a right. This goes, my Lord, to what the court was putting across, my Lord, that it is really enabling the arbitral award rather than finding ways to set it aside. The, my Lord, recourse is a wider term and would include within it the power also to modify or vary. That is, my Lord, the argument already made that the larger power encompasses the smaller power. And then, my Lord, the other point, my Lord, which is already made, but I'll just repeat it, my Lord, there's no prohibition in the Act on the power to modify, and no such power can be read in by recourse to Section 5.
That is also argued by Mr.
Yes.
But I said, unlike the Singapore Act.
Yes.
There's a
There's
prohibition.
an express prohibition. Here, my Lord, there's no express prohibition. And in fact, my Lord, what my Lord Justice Vishwanathan was also putting, Section 5 reads in material part, my Lord, no judicial authority shall intervene except where so provided in this part. So actually, my Lord, it is a gateway for the court rather than an obstacle for the court. To the extent, my Lord, Section 34 is read as a wider power of recourse, it is actually provided for in this part that a Section 34 court can, in its exercise of a recourse to the award, modify the award. That is, my Lord, the last limb of Section 5. My Lord, in paragraph 3, I make the point which your lordships have already, my Lord, heard from Mr. Kambata and Mr. Dattar. Ultimately, the object of the Act is to provide an expeditious remedy. And the last 3 lines of paragraph 3 of my submission, my Lord. If courts exercise the power to modify the award, it will eliminate the formality of going back to a new tribunal to reaffirm a conclusion which has already been reached by the court, thereby ensuring an earlier quietus to the dispute. This, my Lord, forms the basis of, my Lord, the guardrails that I would be submitting for your lordship's kind consideration. My Lord, the point has already been made that in Section 34, it is only 34(2)(a)(4) that expressly contemplated partial setting aside, to the extent that the award is severable to that extent. But your lordships have read that power to encompass all of 34. not limited to 34(2)(a)(4). That is the judgment in JG Engineers and the recent Delhi High Court decision in Trichy, Tanjavur. But in addition to what has been submitted on that point, Your Lordship may note, in the Delhi High Court decision, there is a reference to the earlier versions of the model law that specifically contained a power to partially set aside an award. Those earlier versions did not find place in the final model law. Notwithstanding that, Your Lordships have found that where an award is severable and it does not impact other aspects of the award, that part of the award may be set aside. Even though the earlier versions of the model law had a specific clause, which clause was not contained in the final. That's the only additional submission. And the reason Your Lordships have done that is, again, to make the Arbitration Act workable, to ensure expeditious dispute resolution, and to say that where a award consists of severable disputes, then to the extent of that severance, a part of the award can be set aside. And Your Lordships have gone one step further, my lord. Your Lordships have said it should not even be only textual divisibility, but even substantial severability is okay. Because normally, my lord, the rule of severance was, or severability was, can Your Lordships draw one line through the offending part of the line, a part of the clause or the award. Your Lordships have said we're not looking at it as textual divisibility, but substantial severability. Because, my lord, the argument I think that has found favor with Your Lordships is parties have subjected themselves to arbitration. An arbitral tribunal has correctly decided claims 1 to 5, but claim 6 is liable to be set aside on some head or some ground. That can be severed only to that extent the award can be set aside. And in that sense, my lord, I adopt Mr. Kambata's submission that partial modification, partial setting aside is also modification. Ultimately, Your Lordships are reading section 34 and saying, although it talks of setting aside an award, Your Lordships are saying an award is an agglomeration of various claims. And one part of that award, to the extent it can be severed, can be set aside. Well, paragraph 5, I make the point which Your Lordships have already seen, my lord, that even in Hakim, where Your Lordships found there is no power to modify the award, the modification was upheld, only showing, my lord, that this is perhaps a need for the arbitration ecosystem. My lord, if I may just place one or two paragraphs of the judgment in Hakim. But if I may place only one or two paragraphs in Hakim, this is in the common compilation, page 11. Mr. Dattar's compilation. The very first compilation.
Written on it. Compilation written.
So the judgment starts at page 11.
Yes, please.
Do my lords have it, my lord? Page 11. Well, the judgment in Hakim initially, my lord, proceeded on the basis that earlier judgments of this court had already held that there was no power to modify. And in that regard, my lordship may have paragraph 25 at page 27. Paragraph 25. As a matter of fact, the point raised in these appeals stands concluded in McDermott International versus Byrne Standard, where this court held, and your lordship may come directly to paragraph 52 on the next page of McDermott. The 1996 Act makes provision for the supervisory role of courts for the review of arbitral award only to ensure fairness. Intervention of this court is envisaged in a few circumstances only, like in case of fraud or bias by the arbitrators, violation of natural justice, etc. The court cannot correct errors of the arbitrator. It can only quash the award, leaving the parties free to begin the arbitration again if it is desired. So the scheme of the provision aims at keeping the supervisory role of the court at minimum, and this can be justified as parties to the agreement make a conscious decision to exclude the court's jurisdiction by opting for arbitration as they prefer the expediency and finality offered by it. So, this observation in McDermott, where really the issue of modification did not arise, was the starting point of the analysis in Hakim as to why the courts cannot modify an award. And then, the Lordships, also referred to Kinari Malik, which again, was a case under 34(4) and didn't squarely raise this issue. After finding, at paragraph 41, at paragraph 42 at page 38, paragraph 42 at page 38. Is my Lord the Chief Justice have it?
Yes.
Para 40. It can therefore be said that this question has now been settled finally by at least 3 decisions of this court. Even otherwise, to state that the judicial trend appears to favor an interpretation that would read into 34 a power to modify, revise, or vary the award would be to ignore the previous law contained in the 40 Act, as also to ignore the fact that the 1996 Act was enacted based on the UNCITRAL Model Law on International Commercial Arbitration 1985, which, as has been pointed out in Redfern and Hunter in International Arbitration, makes it clear that given the limited judicial interference on extremely limited grounds, not dealing with the merits of the award, the limited remedy under Section 34 is coterminous with a limited right, namely either to set aside an award or remand the matter under the circumstances mentioned in 34 of the Arbitration Act. Similarly, the court proceeded on the basis, my lord, that there is a limited right conferred in Section 34. And it is that limited right that leads to a limited remedy. A different articulation, my lord, is in the impugned judgment in Gayatri Balaswamy, my lord, the lead matter. Justice Ramasubramanian, as he then was, my lord, says that the remedy cannot be worse than the malady. That's how he puts it. And that is, my lord, in my respectful submission, the issue your lordships are deciding today. Whether 34 is a limited right that therefore gives rise.
There is a way of interpreting 34(4).
Yes.
If we accept there is an implied power or subsumed power of a lesser relief,
Yes.
34(4) can be exercised where the court finds it difficult
Yes.
to exercise that power.
Yes.
Say in a case where documents are not produced.
Correct.
Or hearing is not granted and award is passed. Or otherwise you find that it's not possible to segregate and divide. Then in that event, the court can exercise that power. That's the argument in your favor.
Yes.
The other side can argue the other way around and says the entire power of modification is subsumed in subsection 4 to 34.
Yes.
But you can argue that this will not curtail the power of the court, where they can correct the correctable errors.
Yes.
By the court itself.
Yes. But
curable errors by the court itself.
I'm deeply obliged, because that was my next submission. The argument raised against us is that 34(4) contains the power to modify, and therefore when the Act expressly contains one method to do this, no other power can exist. That's
That's the argument against you.
Yes, that's the argument against us. But the power under 34(4) is very different from the power of modification that we are requesting your lordships to find that the court will exercise while entertaining an application for setting aside. May I, my lord, place one decision of this court, but first, my lord, may I just place 34(4). The submission is this, that perhaps 34(4) is being misconstrued as conferring a power on the arbitral tribunal to modify its award. The scope of 34(4), my lord, is only for a tribunal to cure its defects of reasoning, not to change the end decision of the award. But may I place 34(4) and then the decision in IPA clearing? 34(4), my lord. On receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the arbitral award. And now your lordship will have, my lord, I-pay clearing, which is in volume 4, my lord, of the learned Solicitor General's compilation. Volume 4, 2063. Yes. 2063. But my submission is that this is not a power that allows the court to revisit its award or modify it. That power, if we are right, my lord, lies with the court in certain narrow guardrails. But this is not an opportunity, my lord, for a court to, my lord, send the matter back to a tribunal to revisit its conclusions, to revisit its decision. Your lordship will get that, my lord? 2063 does my lord have?
Yes.
Yes. At 2072, my lord, the judgment discusses an earlier judgment in Dyna, para 34.
Schemes of justice.
In the judgment in Dyna Technologies versus Crompton Greaves, it was a case when there was no inquiry under 34(4) of the Act, and in the said case, this court held that the legislative intention behind 34(4) of the Act is to make the award enforceable after giving an opportunity to the tribunal to undo the curable defects. It was not a case of patent illegality of the award, but deficiency in the award due to lack of reasoning for a finding which was already recorded in the award. In the very same case, it was also clearly held that when there is complete perversity in the reasoning, then the same is a ground to challenge the award under 34(1) of the Act. And then if your lordship has para 38. In absence of any finding on point 1, as pleaded by the respondent, and further, it is their case that relevant material produced before the arbitrator to prove accord and satisfaction between the parties is not considered, and the same amounts to patent illegalities, such aspects are to be considered by the court itself. It cannot be said that it is a case where additional reasons are to be given or gaps in the reasoning in absence of a finding on point number 1, namely, whether the contract was illegally and abruptly terminated by the respondent. Further, section 34(4) of the Act itself makes it clear that it is the discretion vested with the court for remitting the matter to arbitral tribunal to give an opportunity to resume the proceedings or not. The words "where it is appropriate" itself indicate that it is the discretion to be exercised by the court to remit the matter when requested by a party. When application is filed under 34(4) of the Act, the same is to be considered keeping in mind the ground raised in the application under 34(1) of the Act by the party who has questioned the award of the arbitral tribunal and the grounds raised in the application filed under 34(4) of the Act. Merely because an application is filed under 34(4) of the Act by a party, it is not always obligatory on the part of the court to remit the matter to the arbitral tribunal. The discretionary power conferred under 34(4) of the Act is to be exercised where there is an inadequate reasoning or to fill up the gaps in the reasoning in support of the findings which are already recorded in the award. But I'm placing emphasis on this, my lord, to submit that the power under 34(4), if the court exercises in its discretion to remit the matter to the tribunal, which otherwise had become functus officio, is not to, my lord, reverse its findings or modify its findings. It is only to, my lord, give reasoning in support of its findings. And that is why, my lord, 34(4) operates in a different sphere than the modification power we are seeking, my lord, that the court has while hearing a setting aside application. And last paragraph, paragraph 41. Under the guise of additional reasons and filling up the gaps in the reasoning, no award can be remitted to the arbitrator where there are no findings on the contentious issues in the award. If there are...
We have seen that.
Yes. So, that's the submission, on 34(4).
It's not a power, it's not, certainly not a power of absolute rewriting or anything like that. It's certainly not also restricted, limited to the extent probably is indicated here. Depends upon the factual matrix of each case. It will depend upon the issue raised.
Yes.
Suppose some document has not been looked into as a result, or some document is been overlooked or wrongly quoted, or even the ex parte order has been passed, and whereas the notice was not served.
Millard, I'll make this submission, Millard, only as an officer of the court, Millard. I believe that would then be conferring some kind of a review power.
Anyway, we are not concerned
the
primarily with particular.
But Millard, therefore, the submission is limited only to saying that 34(4) is not a bar to find.
It's not a power of absolute review. There's no doubt.
Yes.
About it.
And-
Review power, if conferred, is fine,
Yes.
but not absolute review.
Yes. It's not, Millard, an opportunity for the tribunal to again arrive at a different award. If, for example, Millard, evidence is not considered, then Millard, that may perhaps be the end of the matter as far as that arbitral tribunal is concerned, subject only to your lordship's power or a court's power under 34 to modify or set aside the award. Because otherwise, Millard, we would be conferring on the arbitral tribunal a power to revisit its award, which I don't believe, Millard, the power is under section 34. But the limited submission I was making, Millard, was in response to the submission that since section 34(4) is there in the act, there is a power to modify in the arbitral tribunal, and therefore there is no power to modify in a court. I was therefore, Millard, distinguishing the power under 34(4) from, Millard, the power under the power that we are seeking, Millard, the court exercise.
Mr. Ritanrai, don't you think you're putting it in a very narrow perspective? The power under 34(4), if you go by the language, is not conditioned by so many limitations as you are putting on there.
Yes. Millard, if it were, I appreciate, Millard, this may be too narrow, but Millard, in my respectful submission, a power that allows the tribunal to revise its award.
Not
Maybe.
review the order,
Yes.
but it says eliminate the grounds for setting aside the arbitral
Yes.
award. So if the grounds are identified and thereafter the party makes an application,
Yes.
is there any limit on the power of the arbitral tribunal to set aside those grounds which have been indicated, suppose in the order
As your lordship put it.
passed by the 34 court and highlighted in the application filed by the party?
Yes.
Why can't the arbitral
As your lordship put it,
tribunal
Millard, if there are
set aside
certain
those
grounds that will address, Millard, the invalidity of the award, those grounds can be the matter of an application and then a reference to the arbitral tribunal. But in that application, the arbitral tribunal cannot review its earlier decision, is my defective submission.
Okay.
And that power does not mean that the court cannot exercise the modification power that we are seeking to place and house in section 34.
Again, not to the extent of a review.
I'm sorry, what?
Even the power of modification there would not extend to the review of the award.
Yes, and it would not extend to a review of the award. Well, my last submission before I.
Then what is the meaning of this power, Mr. Rai? Suppose a document is not put,
Yes.
and if the court wants it to send back to the arbitrator 34(4), and if the necessary consequence will be that we don't know what the arbitrator will do after seeing that,
Yes.
after receiving the answer to that document.
Yes.
So is it an empty power then?
Well, that's why the power is, in my respectful submission, quite clear.
Ultimately,
Because
you
Your
say
Lordship-
the award has to be intact.
Yes, because Your Lordship will see that will then open an entire new chapter. If the arbitral tribunal.
Right, probably, just like there be curable defects or issues or curable incongruities emerging in the award which the court
Not affecting the substantive.
Similarly, there can be, in fact, the power of curable to cure the defects with the arbitral tribunal may be larger. Maybe larger. They may be larger than what is with the court. Because the court can only do so when it's possible to segregate.
Yes.
But the court finds it's not possible to segregate, it can exercise that power. 43, if one has to go for fresh arbitration, it's almost a
It's a
de
clean slate.
novo,
It
it's
starts
a
over.
de novo.
No, your lordships are right. Well, the power of modification.
Then it will be virtually like a power of remand, and the power of remand which is exercised by the courts is also now we frowned upon as long as the appellate court itself cannot decide the issue.
Your lordships are right, Millard, because in section 34, Millard, and I'll just come to that after one more submission, Millard, the guardrails are that the court will not review the case on its merits. So
That's fine.
within the confines. So therefore, it
No,
is
no.
narrower in that sense.
Correct, correct.
It is narrower in that sense, my lord. But your lordship may also countenance, my lord, once an arbitral tribunal has rendered its award, to remit in that sense in 34(4), for it to re-examine certain
Can
evidence.
we
that
now
is-
put a simple question? Can we now formulate? The court's power to cure the defects must be such for which they can segregate, divide, and cure the defects without affecting the substratum and the core of the award, without affecting the substantial substratum of the award, so as to segregate the invalid parts.
Yes.
In case of 34(4), where the court finds itself that will not be possible to do so, then they can remit the arbitrator cure the defects. The defects should be such which can result in the award being set aside on the grounds which are mentioned in subsection 1 and 2. Sorry, subsection 2.
Yes. And
2
my
and
lord,
2A.
my submission is that this extends to all of 34, not just, my lord, the head of patent illegality. But,
Obviously, it will-
but my lord, my lord, I'm only placing this in 34(4). I ask myself, my lord, can an arbitral tribunal change the decretal part of the award? And in my respectful submission, my lord, that far it cannot extend.
Are you contradicting
Let's
yourself?
start by this provision which says that the party making the application was not given a proper notice or was unable to present his case.
Yes.
In such a situation, if that party is given an opportunity by sending him back to the arbitral tribunal,
Yes.
so the arbitral tribunal is now allowing this person to come forth with his case.
Yes.
Will it not have the power to review what it said earlier?
My lord, that would be a ground then to set aside the award.
No. Even in fact, let's put it, the Inlays Bank is very clear. The power of procedural review is inherent in every court or tribunal, whereas power of substantive review is not. And
Yes.
procedural review means where you have not served proper notice, proceeded ex parte, and made some mistake, which renders its procedurally wrong.
Yes. My lord, the way, my lord, your lordship may consider the example, my lord, that was just given to me, my lord. The party making the application in your lordship's example would then be making the argument that the applicant in the section 34 has not been given an opportunity of being heard and remand or send the matter to the tribunal. So, my lord, the party is not seeking on its own as to why the matter should be sent back to the tribunal. The party is making an application almost on behalf of the opposite party. And that may be, my lord, extending 34(4) too far. The party that comes in a 34, my lord, challenges the award.
This is the party who's making the application.
My lord, yes,
Go by what 34(2)(3) says.
yes,
Party making the application was not given proper notice.
yes,
Or was otherwise unable to present his case.
yes,
The applicant who's complaining
yes,
that he wasn't allowed to present his case.
yes. That is,
So this provision would be available to the 34 all right, go back,
yes. It would
make
be
an
available,
application
my lord,
to
to
the arbitral tribunal.
yes,
Therefore, in such a situation, the award can always be reviewed.
yes.
Why not?
It would be available to the 34(4) court on an application or request by one of the parties. In your lordship's example, it would be the respondent who would be making that request.
Could be either party.
My lord, and that's what I'm saying, my lord, the
But
respondent.
4 does not speak of only the successful party or the unsuccessful
But then
party.
your
It
lordship-
just says a party.
Yes.
So why should we limit it to one or the other?
My lord, my understanding, my lord, of 34(4).
A party may have succeeded partly in award, but it may be aggrieved by the part to the extent partly gone against him. A party normally will be filing an application in the 34(1) only if they're aggrieved by the award,
Yes.
not if they're satisfied and happy with the award.
And there, my lord, ordinarily the other party would be seeking to support the award.
Correct.
But
But the other
those-
party may then, look, please. As far as procedural review is concerned, we don't require any provision in the act. That's a power which is now well established, is available across to all courts and tribunals without any specific power of review. For substantive review, there must be a power. This goes beyond substantive review. This
Yes.
certainly goes beyond substantive review.
Yes. Look,
What is being put to you is, suppose there are 5 claims awarded.
yes,
4 claims are all right. One claim, one party says is already settled, that document has been suppressed or not produced. Matter goes back. Cannot the arbitrator sever that claim and retain the award for 4 so that the grounds for setting aside is awarded for the court?
But then your lordships are giving a power of substantive review to the tribunal in that case.
Yes, there is.
Because that document was
There
presumably
is.
there before.
Let me put it. Suppose a particular article of the Limitation Act has been applied.
Has been, Millard?
A particular article of the
Yes.
Limitation Act has been applied
Yes.
by the arbitrator. And the court finds that article is not applicable.
Yes.
So the court may record, let it be go back, let him examine, because the arbitrator may have decided that issue and not decided because he held it to be barred by limitation, not gone into the other aspect.
Yes. Millard, my respect
They
to
record
submissions,
that
that would,
this is a position, please now examine
yes.
in light of these judgments, which are clearly against. Like there's a difference between a loan and deposit. You apply the provision of a loan and not the deposit, the answer will be, limitation periods will be absolutely different.
Millard, your lordships are right, Millard, and there are examples. My only submissions would be twofold, Millard. Your lordship, in fact, asked this question last week, that what determination does the court have to make before it, Millard, sends the matter back to an arbitral tribunal? This will raise, Millard, one issue that, in effect, the court is almost finally deciding a 34, but then just stopping short and saying, Millard, go back to the arbitral tribunal.
Correct? That's when they will refer it.
But, Millard, then it would open almost one more round in arbitration law.
But
Where
much
you
better,
effectively
much better
argue
than
the
having
entirety.
de novo arbitration.
Yes. And Millard, the second aspect would be you are still conferring on the tribunal. You are still conferring on the tribunal, Millard, a power of substantive review. Where the tribunal has misapplied, as your lordship gave the example, a limitation act, or Millard, not considered a document that was before it in the proper context. That would, Millard, effectively be seeking that the arbitral tribunal review its own decision. Which decision then, Millard, again, is amenable only to the narrow challenge of 34. And that is why, Millard, in my respectful submission, there may be some cases where a re-arbitration is inevitable because you cannot confer the power of substantive review on an arbitral tribunal. Otherwise, Millard, 34.4 would then become, Millard, a longer process where you would first, as I said, Millard, almost decide the 34 and then send guidance back to the arbitral tribunal as to how to proceed. My, Millard, answer, Millard, then I come now directly to the guardrails that I propose, Millard. And it is very similar to Millard, what Mr. Kambata said in terms of the inevitable outcome. What I am trying to say, Millard, in my submissions is that keeping in mind these two objectives, both finality of arbitral award, but also a determination by parties that they will have an arbitrator decide their dispute. The way these two are reconciled, Millard, is if in a setting aside application, and acting only within the narrow confines of a setting aside application, therefore not reviewing the merits of the matter, the conclusion axiomatically follows as to what will happen in the remanded arbitration. Then to that limited extent, the court can modify the award. So, Millard, for example, in interest, if the arbitral tribunal has awarded interest contrary to the terms of the contract, and that is the reason the award on interest is being set aside, then the court can modify the interest rate. Because in a remanded arbitration or in a fresh arbitration, the only conclusion that will follow is the interest rate as per the contract. So, Millard, the way I try to articulate that in paragraphs 9 and 10 of my submissions, Millard, if your lordship will have it. Modification under section 34 is permissible only in situations where the court does not supplant the role of the arbitrator. Thus, for example, the exercise of modification cannot entail a review of the merits of the dispute. The court must find grounds to set aside the award or part thereof, and if the conclusion axiomatically flows from its findings, the court may modify the award to reach that axiomatic outcome. In that sense, the modification of the award is only a species of setting aside. And I've tried to give Millard two illustrations. Illustratively, if the tribunal awards interest contrary to the express terms of the contract, rather than relegating the parties to another arbitration, the court can grant interest according to the terms of the contract. Or B, if the tribunal finds breach of contract but awards damages even though the contract stipulates liquidated damages, the court may modify the award and award liquidated damages in accordance with the contract. This then preserves for the parties that the decision is not being taken by a court when they have actually an arbitration agreement in place, saying that the arbitrators will finally decide the dispute between the parties. One last judgment, if I may place. This is a Delhi High Court judgment, which puts the submission quite succinctly. That is, in my compilation. What page, Ankita? What page? Page 320, my lord.
Award liquidated damages substitute is also not easy. They have to deal with the extension letters.
No, my lord, if
To that extent is what you're rewriting the award.
no, my lord, if the facts of delay are clear, only to that extent, my lord. If the quantum of delay
Pretty clear.
is already clear from the arbitral award and the court is not interfering with that, then you are doing a simple mathematics of 0.5% per week for X number of weeks. Or, my lord, may I just take, not my example, my lord, a given example as my lord, the Chief Justice put it. If, my lord, the contract specifies a rate for the work to be done, and also specifies that if the work quantity exceeds a certain amount, a higher rate will be given. Let me just end with this one illustration and then I'll place the Delhi High Court decision.
Please, just continue.
Yes. If the contract prescribes a particular rate for the first quantity of work and then a higher rate for the additional quantity, the tribunal awards the higher rate for the entire quantity. And the matter is not challenged, saying that the higher rate can only apply to the additional quantity. If the court is setting aside the award for taking what is not a plausible view of the contract, then the court can certainly, in my respectful submission, modify the award to give that additional rate only for the additional work, rather than set aside the award, rendering the parties back to an arbitration where the outcome is already known. That's one of the facts of my case. I was placing, my lord, this one.
Yes, please.
Yes, at paragraph 21, my lord,
Page
at
number.
page 325.
What's the name of the case?
My lord, this is modern laminators, footnote 8 of my submissions, my lord. 2008 SEC Online, Delhi, 956. These guardrails have been well put, my lord, and that's why I'm placing this judgment.
Modern.
2000.
Oh, you tell me a
Page 320, 320, my lord, of my
320.
compilation.
Yes.
Union of India versus modern laminators.
Filed by Miss Manisha Ambani.
No, my lord, by Mr. Nayak. I think my friend, my court master has pulled it out. No, the 10th,
Additional compilation.
well, it's my compilation, additional compilation. Yes. Yes, my lord. Page 320.
Compilation.
Combined compilation of all the.
Well, I
We should,
therefore,
in fact, sit down together at least 4
no,
5 days.
that's why I didn't duplicate compilations, but what had already been
And
filed by
look,
Mr.
look,
Datar.
all of you have spent so much money also just.
We tried in this compilation but not to duplicate what was already filed.
Okay, yes, please.
Yes, but
You have got a spare copy?
320, my lord, at 325. I'll just place these two paragraphs, my lord. Paragraph 21, my lord, at the bottom of page 325.
Yes, all right.
That's my lord. No, Abbas. Vishwanathan, may I place it while your lordship?
Yes.
In my opinion, the power given to the court to set aside the award,
Paragraph?
paragraph 21, at the bottom of page 325. Does my lord have it?
Yes.
In my opinion, the power given to the court to set aside the award necessarily includes a power to modify the award, notwithstanding absence of express power to modify the award as under the 1940 Act. Just as ONGC versus Saw Pipes interpreted the ground of award being against the public policy to include contrary to substantive provisions of law or against the terms of the contract. SVP interpreted the powers under 11.6 to be inclusive of judicial powers. The speedy disposal of lists is the underlying thought in the radical changes made in the arbitration law. If the powers of the court under section 34 are restricted to not include power to modify, even where the court without any elaborate inquiry and on the material already before the arbitrator finds that the list should be finally settled with such modification, and if the courts are compelled to only set aside the award and to relegate the parties to second round of arbitration or to pursue other civil remedies, we would not be serving the purpose of expeditious or speedy disposal of lists and would be making arbitration as a form of alternate dispute resolution more cumbersome than the traditional judicial process. With great respect, I find myself unable to hold so. The Constitution Bench of Apex Court and SPP reversed the judgment of earlier Constitution Bench, inter alia holding that when a statute confers a power or imposes a duty on judicial authority, that authority, unless shown otherwise, has to act judicially. The Constitution Bench adopted the procedure laid therein in the context of the Act and to best serve the purpose sought to be achieved by the Act of expediting the process of arbitration without too many approaches to the court at various stages. And then, below the guardrail also, para 22, such modification of award would, however, have to be within the confines of interference with arbitral awards as held under the 1940 Act and would not permit the courts to substitute their opinion for that of the arbitrator. Such modification of award will be a species of setting aside only and would be setting aside to a limited extent. However, if the courts were to find that they cannot, within the confines of interference permissible or on the material before the arbitrator, are unable to modify, and if the same would include further fact-finding or adjudication of intricate questions of law, the parties ought to be left to the forum of their choice, that is to be relegated under 34(4) of the Act to further arbitration or other civil remedies. So, my respectful submission is that within the confines of the jurisdiction of Section 34, if the courts are able to find that there will only be one conclusion of this arbitration, even if the matter was to be fully set aside and a new arbitration would to ensue, that axiomatic conclusion, the courts can substitute. Miller, just my final paragraph, because Miller, the expert committee headed by Mr. Vishwanathan Miller, Vishwanathan Committee Report Miller. If my Lord the Chief Justice has para 12 of my submission.
Yes.
For this reason, it is respectfully submitted that the guardrail identified in the TK Vishwanathan Committee report that a court may modify the award only in exceptional circumstances to meet the ends of justice may not be precise or narrow enough to be workable. Similarly, instances where interest rates have been modified on the basis that the interest rate does not reflect the prevailing economic conditions or where it is not found reasonable or in the interest of justice may also be too broad a power to confer to a court under Section 34 of the Act without limiting the power of this court under Article 142. This is, my Lord, paragraph 11 of Vedanta that was placed in the morning. My submission is, my Lord, that within the 34 jurisdiction, within that exercise, and only if an outcome inevitably follows, then the court may modify that award. And, my Lord, your Lordship has been concerned, my Lord, with interest rates being awarded by tribunals, either too much in excess or not being given. My Lord, too much in excess, perhaps your Lordship's decision in Nepal Limited versus Manoj Agarwal, where now a party that deposits the money in court while challenging the award doesn't continue to suffer the interest rate awarded.
So that's your wrong reading of it. That's your wrong reading of it.
Your Lordships have said, my Lord, that
No, in Nepal, the money was paid back, paid to the party.
yes, taken out from the court by the party.
That therefore I said the interest will stop. Right?
I'm grateful, my Lord. And your Lordships are routine, my Lord, the courts are
Stop
routinely.
it. If you bear deposit, the interest rate doesn't stop.
Correct, you are disputing the liability. That's settled, Ramanathan Chettiar.
No, what,
In
what I
Chettiar.
said, where the money has been paid to the party,
Yes, that's
withdrawn by the party, then it makes no difference, but where deposited the money, you don't,
No, yes, I'm grateful. Lord.
you don't save yourself from the interest.
Yes, your lordships have said where it's deposited and withdrawn.
Maybe withdrawn also on furnishing security. In
Yes.
that case, it was made, it was not a bank guarantee and so forth.
Yes,
In bank guarantee cases, then we are asking them to pay even the bank guarantee.
a bank
charge.
guarantee or some other security. That was my submission, my lord, that today, my lord, if a party is aggrieved by an award and the interest rate is very,
What was being asked for was, the money was taken away and utilized whatnot. Now the award was upheld, so he said, no, now you pay me interest on that amount, even including the amount which I drawn.
I was only trying to say, my lord, therefore, this issue of a very high interest rate has been largely addressed by your lordship's decision, because when you suffer an award and you are challenging the award and the interest rate, you at least deposit the money in court, it is withdrawn by the other party on furnishing a security.
So the times the government it suffers on this account because they say don't allow withdrawal.
No,
They
then,
deposit the money, but
my lord,
don't allow.
in that sense, my lord, and your lordships, my lord, have to deal with, my lord, a variety of arbitrations, my lord. But in a commercial arbitration, if a party refuses to comply with the award, then perhaps years later, it can only suffer the consequence of that high interest. I hope and that's why, my lord, NEPA offers that opportunity to a party to say that if the award of interest is too high, you can stop the clock by depositing the money, and with an order of a court, the other side is permitted to withdraw the money. But if you don't deposit the money or resist a withdrawal of the money by the other side, then perhaps you don't need the discretionary relief of a court to later say the award of interest is too high. I'm very grateful, my lord. Therefore, I would only end with this.
Yes, please.
My lord, I would only end with this one last line. The Lakshman Rekha, according to me, is, my lord, that courts will not substitute the decision-making of an arbitrator. Within that confine, and acting within section 34, if there is a certain conclusion to the dispute, the courts are, my lord, empowered under section 34 to make that modification. I'm deeply obliged.
Sir, I am principally concerned with statutory arbitration.
You are appearing in which case?
In high number 100523.
Okay.
And other
Statutory arbitration arising out of?
National Highways Act.
You're for the private party or the?
Private party whose land is acquired. So my first submission is that there is a fundamental difference between statutory arbitration under the National Highways Act and arbitration under the Arbitration Act. Arbitration under the National Highways Act involves public law elements. How to determine the compensation for the land which is acquired? All principles fall in the domain of public law. While commercial arbitration involves private law elements. This is one fundamental difference between the two. The second difference is that commercial arbitration is consensual. It's with the consent of the parties. While statutory arbitration is involuntary. I do not choose the arbitrator. Under section 3G, the arbitrator is appointed by the central government under the provisions of the National Highways Act. This court has noted in Hakim's case that there is inherent bias. Kindly see me not para 50, 55 and 59 of Hakim's case. It is there in Mr. Datar's compilation.
Para?
para 50, 55 and 59. And apart from this para, your lordships can take judicial notice of the fact that several cases have come to this court where the amount which is awarded under such arbitration is very small.
Very big.
That is why your lordships have interfered under Article 142. Even in this case, Hakim's case, your lordships have interfered, exercised power under 142, and your lordships have declined to interfere with the impugned award. So kindly see para 50. There is no doubt that, as argued by Mr. Balasubramaniam, the arbitral award in these cases is given by a government servant appointed by the central government, the result being the rubber stamping of compensation awarded or a completely perverse basis, given the facts that in these petitions at least, the constitutional validity of NH laws has not been challenged. We must proceed on the basis that a grave injustice would be done if we were to interfere on facts, set aside the award, and remand the matter to very government servant who took into account depressed land values which were relevant for the purposes of the stamp duty only. It may be mentioned at this juncture that a limited challenge was made to Section 3J of the National Highways Act. Now this has been struck down. Then kindly come, my lord, to para 55.
Validity is pending, I think now, on 3G is pending.
3G is pending.
3J is struck down now.
Struck down.
So therefore,
3G is pending.
no, 3G, this arbitration was under 3G.
It's pending, validity is pending.
So 3J is struck down. Therefore, all the principles which apply to acquisition under the Land Acquisition Act apply with equal force to this acquisition also. Now kindly see, my lord, para 52 on page 31 of the report. As has been stated by us, the object of the NH laws is to expedite the process of acquisition. This has been achieved by cutting down the period for hearing the objections from 30 days under Section 5 of the Land Acquisition Act to 21 days under Section 3C of the National Highways Act. Further, unlike the Land Acquisition Act, moment the notification under Section 322 of the National Highways Act, equivalent to Section 6 of the Land Act, is made, the land vests absolutely in the central government, free from all encumbrances. Therefore, where the land has vested in the central government and the amount determined by the competent authority under Section 3Z as compensation has been deposited by the central government in accordance with Section 3H1, the competent authority may also direct that possession be taken within so and so. Then kindly come to para 55. It can be seen from the aforesaid provision that the speeding up of acquisition of land needed for national highways has been achieved. The challenge process to an award passed will of necessity take its own time, both under Section 3G of this Act as well as under the provisions of the Land Acquisition Act. This being the case, it is a little difficult to appreciate as to why the wholesome regime of appeals under the Land Acquisition Act has been replaced by a regime in which an award passed by the arbitrator, who is not consensually appointed but appointed by the central government, can only be challenged not on merits but on the limited grounds contained in Section 34. Now this is precisely what my contention is. Now therefore your lordship will see that if there is a fundamental difference on two counts, one, the applicability of the substantive law, and second, the absence of consent, these two elements would have their own impact on the power of the court under 34. Now, as far as statutory arbitration is concerned, therefore, there is a fundamental difference between statutory arbitration and commercial arbitration. Now, in this light, kindly come, my lord, to one more aspect. Hakim notes the judgment of the Constitution Bench in Nagpur Improvement Trust. Kindly turn to para 58 on page 33.
Yes.
It is now well settled that the state can make reasonable classification for the purpose of legislation. It is equally settled that the classification, in order to be reasonable, must satisfy two tests. Differentia must have a rational relation with the object sought to be achieved by the legislation in question. In this connection, it must be borne in mind that the object itself should be lawful. The object itself cannot be against the sections of my discriminatory for otherwise. For instance, if the object is to discriminate against one section of the minority, discrimination cannot be justified on the ground there are reasonable classifications because it has a rational relation to the object sought to be achieved. What can be reasonable classification for the purpose of determination of compensation if the object of the legislation is to compulsorily acquire the land for a public purpose? It would not be disputed that the different principles of compensation cannot be formulated for lands acquired on the basis of the owner is old or young, healthy or ill, tall or short, or whether the owner has inheritable property or built it up with his own effort, or whether the owner is politician or an advocate. Why is this sort of classification not sustainable? Because the object being to compulsorily acquire for a public purpose, the object is equally achieved whether the land belongs to one type of the owner or another. Can classification be made on the basis of a public purpose for the purpose of compensation for which land is acquired? In other words, can the legislature lay down different principles of compensation for lands acquired, say, for hospital or a school or a government building? Can the legislature say that for a hospital land will be acquired at 50% of the market value, for a school at 60% of the value, and for government building 70% of the market value? All three objects are public purposes. And as far as the owner is concerned, it does not matter to him whether it is one public purpose or the other. Article 14 confers an individual a right in order to justify classification. There should be something which justifies a different treatment to this individual right. It seems to us that ordinarily classification based on public purpose is not permissible under Article 14 of the for the purpose of determining compensation. The position is different, etc., etc. Now, therefore, the principle that emerges is that whether you acquire under the Land Acquisition Act or whether you acquire under the National Highways Act, I must get the same level of compensation. Now, if this is the principle, will it or will it not have an impact on the content and the amplitude of power under 34?
The difficulty is the challenge is on the restricted ground of 34. It makes no difference.
I'll come to 34.
But if we accept that the grounds of challenge can be increased or decreased depending upon this, whether departmental officer is an arbitrator, as it used to happen before the constitutional bench says independent arbitrators have to be appointed, it will lead to a problem. But we can't expand and decrease the scope of.
So the principle as far as substantive law is concerned is same.
Put it may be a indirect influence, not a direct influence, as far as 34 is concerned.
The Article 14 has other dimension. Now, this is as far as substantive law is concerned. Now, as far as the forum is concerned, in my respectful submission, Article 14 will have its impact on the content and the amplitude of the power under 34.
What precisely is your argument?
My argument is this, that in case of commercial arbitration, the private law elements are involved. While acquisition of land for a public purpose under the National Highways Act or under any other compulsory law of acquisition, the parameters are different. And if that is so, and if the arbitration is involuntary, the jurisdiction of the court under 34 must be differently viewed. you cannot have, if you have the same standard in all cases, whether commercial arbitration, consensual arbitration, compulsory arbitration, public purpose, etc., then two dissimilar situations, jurisdiction will be same, and that would be violative of 14.
Lateral arbitration, particularly after court, these provisions have become suspect, subject to what the
So
union.
the remedy also must be of the same level.
How can 34 scope be different, Mr. Nagde?
The 34 scope will be different for the simple reason that the parameters
If he's violated the statutory provision, and that is the cause for the patent illegality or fundamental, then in that case, we can expand, we can stretch that illegality. But the power of modification has to be read into 34, or under 34(4) as it
I have
may be.
still not touched 34. I'll come to 34 a bit later. But
We have understood this
my
argument.
proposition
We have,
is this.
we have
Now
understood
take a
this.
case, for example, your lordships have said if the acquisition is under the same notification, then the rate of compensation to two different owners must be same. Otherwise, there is infraction of Article 14. Now, suppose in a case arising under the National Highways Act, two different owners are given two different rates of compensation and their properties are acquired under the same notification. Then a restricted view of 34 would warrant that the discriminated owner has to go back and start the process all over again. Now look at the kind of injustice. It will defeat the very objective of expeditious resolution of disputes. I am not saying that in every case the court will have power to modify. But to say, to take an extreme proposition that in no case the court can modify would be too wide a proposition. Too wide a proposition. Now, sir, come to section 34. Let me make my submission on 34. So first, this power is conferred on a civil court. If your lordships may have a look at the definition, it says a principal civil court of original jurisdiction which could have taken cognizance of the subject matter of the arbitral dispute. Now, why this power is conferred on a court and not on a person or designator? There is a reason for it. And we proceed on an assumption that when Parliament enacts a law, the Parliament is aware of the existing law. Now, what is the existing law as far as the civil court is concerned? Two propositions. It can take cognizance of matters of a civil nature unless its cognizance is expressly or impliedly barred. That is proposition number one. Proposition number two, that it has inherent power to do justice. Now, in order to curtail these powers, that is power to take cognizance of matters of a civil nature and power to pass such orders as are necessary to meet the ends of justice, you need specific legislative provision. In the absence of any prohibition or any absence of any restriction on the exercise of this power, the court is free to pass any order that is required to meet the ends of justice. Now let me show to your lordship in this context what fetters have been placed on the powers of the court. So first kindly come, my lord, to section 5. Section 5 of the Arbitration Act. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. In the absence of this, a civil court was competent to take cognizance of a matter of a civil nature. Under the 1940 law, merely because there is an arbitration clause, the court's power to adjudicate upon such a suit was not taken away. In fact, under that law, the court was required to pass an order staying the suit and allow the arbitration to continue. But if that was not done, any arbitration that would continue without the court stay would result in a nullity. So, Section 5, therefore, alters the existing law. It's a fetter which is placed on the court's power. And why those provisions in the 1940 Act? The reason was that the court was competent to take cognizance of the matter, but if there is an arbitration clause, the court is empowered to stay the suit. In other words, the court puts a fetter on its own jurisdiction. Now, this is completely altered by Section 5. And the proposition is that any provision which restricts the power of the civil court must be strictly construed. So if two views are possible, then the one in favor of the jurisdiction of the court must be preferred. And this is precisely the present situation. Then kindly, sir, Section 8. A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting the first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Now, this fetter is couched with rider. It says that if the court prima facie forms a view, then only this power can be exercised. So therefore,
On an application, Mr. Navde.
on the application,
Suppose somebody doesn't apply at all.
then the suit will proceed. That's what I'm saying. That therefore your lordship will have to see the provisions of the act in that perspective, that whether there is a fetter and whether the court's jurisdiction is completely taken away to pass orders on even on merit, then your lordship will come to section 9(1). A party may before or during arbitral proceedings or at any time after making of the arbitral award, but before it enforced in accordance with section applied to the court. So again here some fetter is put on the court's power under 9(1). Then kindly see 9(3). Once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1 unless the court finds that the circumstances exist which may not render the remedy provided under section 17 efficacious. So here again, a power has been restricted, but in certain circumstances, the court can still exercise power under section 9. Then your lordship will come to section 11(6)(a). The Supreme Court, or as the case may be the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall notwithstanding any judgment, decree or order of any court, confined to the examination of the existence of an arbitration agreement. So the jurisdiction is restricted. Then your lordship will come to 37(3). So kindly see 37(3). No second appeal shall lie from an order passed in an appeal under section, but nothing in this section shall affect or take away any right to appeal to the Supreme Court. Then your lordship will come to 42. Notwithstanding anything contained elsewhere in this part or any other law for the time being force, where with respect to an arbitration agreement, any application under this part has been made in a court, that court alone shall have jurisdiction over the arbitral proceedings and all subsequent applications arising out of the agreement and the arbitral proceedings shall be made in the court, in that court and in no other court. So therefore, your lordship sees that whenever the legislature wanted to put fetters on the court's powers, it has done so. Now I come to the second proposition. Court has inherent powers. I take it that nobody is disputing that the power under section 34 is a judicial power. In any case, that issue has now been resolved in Patel engineering case, that even power under 11 is held to be judicial. Now, if it is a judicial power, where is it defined in crystal clear terms? If it is not defined in crystal clear terms, then a proposition follows that it's a power which is not limited by any limiting factor, which is to be found outside the provisions of the Act. So if any limiting factor is to be found on the court judicial power under 34, it must be found in the Act itself. If cannot be found in the Act itself, then in my respectful submission, that power remains unlimited.
Only if 34(2).
I'm coming to 34(2). Now I draw distinctions between section 34(2) and section 34(2)(a) on the one hand and 34(1). Now 34(2) and 34(2)(a) deal with jurisdictional issues. They do not define the powers of the court under 34. They are jurisdictional issues, that when can a court take cognizance of a matter under 34 when the circumstances enumerated in section 34(2) and section 34(2)(a) are shown to be existing. The power flows out of 34(1). That's my submission. Now kindly see 34(1). Recourse to a court against an arbitral award. Now my emphasis is on the word recourse to a court against an arbitral award. Now that recourse is for what? What is the concept of recourse to a court? This concept necessarily postulates a power, a right to seek justice. No other interpretation is possible. It's a recourse to seek justice. And therefore, if it is a judicial remedy, and if section 34 does not define or does not limit the court's power, then in my respectful submission, the court has power to touch even the merits of the case. So the second aspect now,
Yes, please.
now let us take a case where the award is set aside, but the list still survives. Now take for example, the arbitrator wrongly rejects the claim, contrary to all settled principles, or does not allow substantial evidence to take part of the record. Complete denial of natural justice. Award is required to be set aside. That does not put an end to the list. If the list survives, then there are four possibilities. The court says nothing. Because if we go by the rule of strict interpretation, after setting aside the award, the statute does not make us wise as to what is to be done.
No, 43 does provide for that. 43 does provide for that. Section 43 does provide for it.
So
Says
I'll
both
come to
options.
that.
Gives you two options, either to go
That
to
I
the
will
court.
come to 30. I'll come to that provision, subsection 4 of section 43 a little later. But 34 does not. 34 does not itself say. There cannot be vacuum. The list remains, there can't be vacuum. Now kindly have a look at, in this context, 43.4.
Yes.
Too literal an interpretation of 43.4 will play an havoc. Where the court orders that an arbitral award be set aside, the period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the time prescribed by the Limitation Act for commencement of proceedings. Mark that word, proceedings, including arbitration with respect to the dispute so submitted. Now, this provision contemplates two things: arbitration proceedings and some proceeding dehors arbitration. Now, will it be a suit? What is the nature of that proceeding, which is other than arbitration proceeding? So my respectful submission is that 34 does not tell us. I'm not on the content and the amplitude of the power. I'm on whether it is original. The court jurisdiction under 34, is it original? Is it appellate? Or is it revisional? Whichever way that your lordships are inclined to take a view, the court still has the power to pass appropriate orders. Otherwise, there would be a vacuum. The court simply sets aside the award and leave the parties to decide for themselves what is to be done. This creates a situation of uncertainty.
Why, Mr. Navade? Suppose it is set aside on the ground that it contemplates matters beyond the scope of arbitration.
Then matter ain't no. Therefore, I said where the list survives.
List survives, and that will be suit because it's not arbitrable and period is excluded.
If it is not arbitrable, then the party concerned would take appropriate either a suit. Take for example testamentary matter, not arbitrable. Then the party concerned will go and file a suit or testamentary petition or whatever is the remedy. But the point is that the list survives. It may survive not for the purpose of arbitration, but it does survive.
So there are two things. Why they say list survives. Sometimes when you decide the matter in the section 34, the list may not survive. Suppose it says, comes to the conclusion that the first arbitration, that the termination of the contract is valid, and that is upheld by the court.
So that's what I
That's
said.
been upheld by
If
the court.
therefore,
But where the court interfered was with regard to, say, a small aspect with regard to the the enhancement of prices of the goods or the services. That the court says in terms of the arbitration clause, that could not have been awarded. The list doesn't survive. Where the list survives, you'll be entitled to exemption. This was there in the fourth schedule of the 1940 Act.
but the question is, if the dispute is arbitrable, so I am concerned with the question where the dispute survives, the list survives, and dispute is arbitrable within the four corners of the arbitration clause. Then what the court is supposed to do? Because 34 does not tell us, 43(4) also does not tell us what consequential orders the court should pass.
You'll have to either go in for 11.6
So
for
therefore-
appointment of a fresh arbitrator or file a civil suit. In that, you'll say my list survives.
So the act does not tell us that in such a situation,
Why will the act tell you is your, why will the act tell you? Will not guide you, hold your hand and tell you. It's so that that's why we have lawyers.
I can suggest a better answer with respect, my lord.
Yes, please do.
Now take for example 32. The arbitration comes to an end once final award is passed. Unless for other reasons that time is over, etc. Now once the award is set aside, there is no award in operation. Therefore, one can possibly take a view that the arbitration automatically revives.
That's not provided in the act.
That's what I'm saying.
No, it is not provided. Automatic revival is not provided.
Their act does not say so. Act does not say so. The point is, now take for
In fact,
example,
in one of the
take-
cases, with Brother Sanjay Kumar, it was a case in which, there was a claim made against the insurance company. Insurance companies, the arbitration clause does not permit you to arbitrate on the question whether the claim is payable. Only on the question of quantum of claim, arbitration is possible, as per the decisions of this court.
sir, take a case.
So there, the third bank came in and moved an application to Section 8, which was allowed. And the matter was referred to arbitration. Award was pronounced, it was struck down that the arbitration clause is limited. We passed an order reviving of the suit, because there, it could have been possible because the suit was already pending.
Suppose the arbitration revives, it will be again the same round, challenge under
Yeah,
34, and this can continue ad infinitum, then the cost involved in
That-
arbitration.
That is
time
always so in remand.
So therefore, now 34 does not even contemplate even remotely of remand. Now one example I'll give you. Section 37 did not prescribe limitation. Your lordship read into it. Your lordships read into it because of.
Now we've removed it, we've made it applicable as per.
Question is therefore, your lordships are reading, not take for example, an arbitrator
I couldn't
being
understand.
appointed only
We have-
by one party.
Mr. Nafti, we have understood this argument. Anything else now on this?
So therefore, there is a void. Now, Mr. Datar argued that then supply some words. I am dealing on that part of the, I perhaps do not agree with him on that part of the matter. Your lordships have consistently taken a view that a case of casus omissus is to be rarely and rarely invented. And in the absence of a clear-cut measure, your lordship have to see the scheme of the act, the object to be achieved, what remedies, judicial remedies are provided for. Now, in my respectful submission, in this case, we don't have to go in search of casus omissus. We don't have to supply words. The answer is to be found in section 34 itself. And that answer is this. Take a case, for example, where there is enough evidence on the record of the arbitrator but he does not follow. I'm not saying wrong application, because now wrong application also door is sought to be closed by the proviso to 34(2)(a). I'm conscious of that.
So you are in favor of court taking.
But suppose he does not follow. Now take a case of Solicitor. Take a case of Solicitor. The arbitrator does not grant Solicitor. What is to be done? The court is powerless. Now that would render that remedy under 34 an illusion. An illusion. The remedy has to be effective. And that has to be effective within certain definite time span. Least expensive. If these are the twin objectives of the arbitration law, then asking him to go back and then take it years, and by that time the real value of the money, what I get today, 100 rupees, after 20 years, it will not be even worth 1 rupee. This is the situation. Therefore, in my respectful submission, two propositions. One, that we are dealing with dissimilar situations, public law element in statutory arbitration, involuntary arbitration, as against that commercial arbitration based on contractual obligation. Therefore, we cannot have a same standard to measure the width and the amplitude of the court's power under 34. Otherwise, it will lead to infraction of Article 14.
Okay, thank you. Yes, please.
One minute. Sir, before I close, I don't want to show to your lordship, but there are several statutes which deal with statutory arbitration. Atomic Energy Act, Chit Funds Act, and all wherever this statutory arbitration is provided for, there are different parameters. In some cases, appeals are provided for.
Correct.
In some cases, a different kind of procedure is prescribed. Now, therefore, we cannot have one standard measure to assess the width and the amplitude of court's power under 34. It will be in my respectful submission.
Nowadays, you may be better off. Since power is not traceable, you may file a writ petition and show discrimination and get relief.
No, but
Whereas the private party
then all principles of administrative law must apply. And then who can apply?
So if power is not located in the act, then it's not barred. You may file a writ.
No, but then if moment I come under 226, the first thing High Court tells me there is a remedy under 34.
No, but 34 doesn't provide for what you asked.
Then your lordship will have to hold that this is an illusory remedy, not effective.
According to what they say, and if we accept 34 doesn't provide for it,
No,
then
therefore,
it's a remedy only to be ventilated before the writ court.
therefore I am trying to avoid a situation that remedy becomes an illusion. So may I hand over the list of only those statutes?
That's fine.
List of
Yes,
those
please.
statutes. Because
One
your
by one
lordship
now.
have to consider this.
5 minutes now. 5 minutes and we
Will not apply of the act.
Yeah. And sir, one more.
One by one. If you give in your slips, they call you by name.
And the second is the list of provisions of the Arbitration Act which can never apply to involuntary arbitration. Take.
Okay. All the names.
I am grateful. It is lot.
Compilation we are handing over and appearing for a PSU, TCIL, and not the primary line of argument that we are having is for modification. If Lordship will just have the compilation, but we also have a ready compilation of chart. What we have done is we have put a comparative of all sections, but I'll first not begin with the what is the theme of the blood argument. Blood, the theme of the argument, we are not going presently on 34 because blood almost everybody has argued on 34. Your lordship, blood, when the question was referred to this bench, also covered section 37, my lord, which for its scope and powers. So, my lord, we are going to start with section 37 because, my lord, our argument is that if section 37 is examined closely, and our argument is twofold. First, that it is the first appeal. Unlike, my lord, the argument which is being raised, it appears to be a second appeal, which is actually a first appeal. Your lordship will see that from.
We are not examining that question. We'll leave it aside. Whether the power under 37 is equally wide as 34 or more restricted as some judgments have said, we are not going to go to that.
My lord, that will be necessary for a moment, my lord, for a simple reason. Your lord.
Only to the extent modification. If we hold.
Lord, I'll just clarify. Just for once your lordship, Lord, once your lordship sees it. Lord, the argument is simple. As far as Lord, today we have two, in fact, sides of judgments. One which says, my lord, that 37 is narrower than 34. That's the one line of argument. The second, my lord, which is the liberal one, says that 37 is at best equal to 34. There is no line which says that 37 is actually.
That can never be.
Lord, your lordship will bear with me for 5 minutes, then I will leave it to your lordship. Lord.
Are you propounding 37 is wider than 34?
Yeah, absolutely, my lord. We are saying 37 is like a regular appeal. If your lordship, my lord, sees.
If the first trial court cannot go into the question, the second.
No, that's the reason. If your lordship, my lord,
okay, please argue on that.
Yes, my lord. Answer to that lies in section 36. If your lordship sees 36, my lord, it will become clear. My lord, and the answer is after 36, because 36 uses two phrases. First is decree, that it award. It doesn't say, my lord, at the stage of the award that it is a decree. It says at 36, after the 34 scrutiny is over, that it becomes a decree of the court. And then it says in 36.3 that it is to be treated as a money decree. If your lordship will just have 36, my lord, for a moment. And Lord, I will also clarify why this power has been kept separate. And what are the kind, Lord, your lordship will also have to keep in mind that when we adopted the UN sectoral model, there are few provisions which are there only in our act and it is not there in the UN model. For instance, 34 capital 2A, which provides that two critical elements, that is the power to reappreciate the.
We are aware of that.
So, my lord, those two have been specifically kept in our act. They are not there in the UN.
But come by way of amendment.
Yes, my lord. My lord, your lordship will see 36 now.
Yes, please.
36, where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with provisions of the Code of Civil Procedure in the same manner as if it were a decree of the court. Then your lordship will turn to the proviso of 3.
Yes, please.
Upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such conditions as it may deem fit, grant stay of operation of such award for reasons to be recorded in writing, provided that the court shall, while considering the application for grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of a money decree under the provisions of CPC 1908. That's Order 41, Rule 5. So, Lord, we have a position where 36.1 is talking about it being treated as a decree, and 36 Proviso 3, which says that it is to be treated akin to a money decree. Now, my lord, your lordship will turn to 19 for a moment.
Section
19. Section 19, lord, which says determination of rules of procedure. Because, lord, the argument is also that CPC is not only a procedural law. To the extent an appeal is provided, it can also be considered as a substantive law. Your lordship has dealt with that, lord, in a number of judgments. 19.1. The arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Now, Lord, the argument which has already been upheld in ITI, the judgment which by Learned Fred read in the morning, was that it is not bound, does not mean that CPC is excluded. It only says that the view can be more liberal. So other than the principles of CPC and Evidence Act, an arbitrator could probably go and have a more liberal view. And in fact, that is the reason I am saying that the scrutiny of 37 has to be more rigorous, because 34 provides only for a curtailed scrutiny, and it is like it's a position, I would say, to the extent of to the extent of saying that it merges into the award, and it is for the first time in 37 that the decree or the award merging with the 34 order is actually tested. That is the reason, my lord, your lordship will not find any other
We have
provision.
understood that argument. We probably say it's not a case of reverse pyramid.
Lord, okay,
Yeah,
Lord, leave that argument for the moment.
Yeah,
The lordship will now turn
come to any other argument.
Yes, my lord. Your lordship will see 19.4. 19.4 for a moment, my lord. The power of the arbitral tribunal under subsection 3 includes the power to determine admissibility, relevance, materiality, and weight of any evidence. Now, my lord, please envisage a position where there's an arbitrator who is not even a law graduate, because the International Act has provision where experts like architects or other construction experts can be arbitrators. Now he is going to determine things under 19.4 with respect to admissibility, relevance, materiality, and weight of any evidence. Now, please, in this background, my lord, please come to 28 for a moment.
Yes.
28, rules applicable to the substance of the dispute. This is, my lord, where we are building the power for 37. Where the place of arbitration is situated in India, in an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. So, Lord, CPC in that sense, when it provides for an appeal, here we have a section 37. Lord, I am not.
Mr. Pushkar, do not press this point more.
Okay,
You're not going to carry it forward.
No, Lord, just one more power can I?
We have understood, but it's not going to help
Okay,
you
Lord,
further.
your lordship.
You're curtailing somebody else's time.
Okay, Lord. What 3 and 2, your lordships, when your lordships is reading, can 3,
We
20
go
and
through
3
your
and
written
2.
submissions that with regard to 37, but we not press that one.
Okay, Lord, then your lordship will also, Lord, in that light, come now to 34, 2 capital A.
Yes.
Now, Lord, 2 capital A. And the reason I was reading that
so many lines.
Lord, 2 capital A.
34 to A.
Yeah, 34, 2 capital A, Lord.
That has been read from yesterday, so many.
Yes, Lord, I want to probably read it.
So you make your submissions, there is no point in reading it again.
Lord, I will only read the proviso, Lord. Can I read the proviso?
Yes, please.
Yes, Lord. That an award shall not be set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. So, Lord, this was the reason I was reading 28 and 19 to say that those are the aspects which 2A has been specifically brought in our statute.
Let us put it very clearly. The argument that 37 power is wider than 34 is unacceptable. Maximum you can argue is 37 being your first appeal. The power will be coterminous as wide as 34. Subject to, obviously, in case there is on the ground of perversity or fundamental laws of India, there is a finding. Probably if two courts, a tribunal and the trial court have examined that issue, one will say that one should not interfere even if one has a different view. That is something which we do when we hear appeals on bail against we do for when you hear appeals with regard to cancellation of bail or acquittal, etc. That's all.
Lord, I would only say that your lordship says, I bow down to Lord of obviously what your lordship is saying.
That
37, 3, Lord.
Please, I don't think this will carry water. Let me very.
Lord, then I would
You
only
are not
say
right.
this
You are not,
as-
Mr. Pushkar, you are not right in assuming that moment a 34 is dismissed, it becomes a decree. Even on filing of a 34, unless there is a stay, it's an enforceable award after the 2015 clarification. The law, according to the court judgment, is always like that. 37 moment it is filed with party as a prima facie case, there would be again an interim or suitable interim order. So again, it won't, you are assuming that it is at that stage a decree and proceeding and forgetting the principle that an appellate power is coextensive with the original power. So please leave that argument as a Chief Justice.
Lord, I go down to that. Your lordship in the warning, Lord, if your lordship recollect, spoke about 151 CPC and the inherent powers. Now, Lord, when your lordship was talking about 151 CPC, it was in that light, Lord, order 47, order 41 Rule 23 to 33, my lord, would also become relevant for reading along with 37C. Because, my lord, what happens when the court receives an appeal under 37C?
Mr. Prashkana, don't press this more.
I'll leave it
I
to
don't
that,
think
but
it's
I
going
have
to cut
make an
time.
argument that's the
And
point.
36(1) was, what you read was originally enacted, then 2016 amendment, it was broadened to make it more enforceable. So leave that, let's not go into all that. We cannot accept the argument that 37 power is greater and wider or broader than 34. Sorry.
That's the reason your lordship.
It's too, that do not convey the point anymore.
I'll leave it there. I'm not for the benefit of this court. I have a chart, not I'll just hand over.
Okay, that is
This-
that.
This has a summary.
Yes,
of,
please. Anybody else?
Provisions, my lord, which we have discussed.
Call out the name.
Yes, sir.
Grateful.
So just 5 minutes, I think. The night watchman, my lord, all most points covered, my lord, and just 3 points I want to point out. Just give the written submission. One of the 3 points which I'd like to focus on, and very quickly, my lords, is that under section 34, my lords, there's the inherent powers of court and there's a discretionary power. There is a discretionary power which is there under 34, and that gives its own power to modify. That's where the power of modification arises from. That is number 1. Second, from that discretionary power also arises the power to sever parts of the award and set it aside. That's where it arises from. And if, my lords, there is no issue between the other side and us that severability is acceptable, then severability is also a kind of modification. That I will just show one judgment on that. Now, if severability is a kind of modification, my lords, there is no bar on other forms of modification by the award. That's the second point I want to highlight. And the third part which I want to highlight is the nature of modifications. My learned friend has already read modern laminators, just 1 or 2 points there I'll put. So, my lord, just starting first, may kindly come to 1.1 of my submissions. That talks about 34 of the Arbitration Act. The Act gives a discretion to the court not to exercise the ultimate power of setting aside in every case. This is clear from the use of the word may. And in that case, in that context, my lords, I have cited R.S. Jivani case, that is PDF 258 of the judgment, common compilation of judgments, PDF 258 at PDF 286, where para 16 it is stated, may indicates that larger discretion is vested in the court, which has to be exercised in accordance with the settled canons of judicial discretion. And the context would require that the expression may should be read as may alone and does not invite any other meaning or interpretation. So, my lords, with the inherent powers of the court, with this concept of discretionary power, which is there, my lords, to be exercised for judicial, as per well-settled judicial canons, my lords, I would suggest that this is the origin of the power which would come to modify the award. Then, my lords, may kindly come to cases where, my lords, in 1.3, that where parts of the award have been set aside on the ground that it is, my lord, the logic which is put forward, which is that each part of an award is like an interim award. The severability is distinguished from modification in the Delhi High Court judgment by Justice Verma by saying that each claim is like an interim award. If you set aside that interim award, that part of the arbitration goes is actually a power of setting aside which is being exercised. My lord, with respect, my lord, the argument which I would comment is this. The Act distinguishes between an interim award and a final award. It provides procedures under which a final award is to be passed. Once a final, unlike an interim award, which is passed and it can be challenged also, the arbitral proceedings cease on a final award being given. Once the arbitral proceedings cease and it becomes a functus officio, my lords, it's treated as a final award. Now to read in a fiction into that, contrary to the Act, that actually, no, it's not a final award, it actually is a conglomeration of different sets of award, is stretching the language too far. I would rather comment the argument that, my lords, actually this severance is a form of modification. It's one type of modification. And under section 34, that is not the only type of modification which can be exercised. There can be other types of modification of award within certain guardrails, which I will point out. So, my lords, I come to straight away at page 3 of my written submission, 2.1, where I've defined modification as a change to something, an alteration or amendment. And then, my lords, Puran Lal Lakhanpal, I have quoted, my lords, I'll pass on the judgment. I won't take time to read it out, but just the relevant para. The word modify means inter alia to make partial changes in
to change as object in respect of some of its qualities, to alter or vary without radical transformation. Similarly, the word modification means the action of making changes in an object without altering its essential nature or character. The state of being thus changed, partial alteration. Stress is being placed on the meaning to alter or vary without radical transformation on behalf of the petitioner. But that is not the only meaning of the words modify or modification. The word modify also means to make partial changes in, and modification means partial alteration. So, my lords, that is the scope and ambit of modification, which has to be given full play to from the discretion of the court under 34(1). Then, my lords, I may just come down to the final point which I want to make. I won't take much time. And that is the nature of modifications, other kinds of modifications can be carried out. It would be dangerous to limit it to certain types of modification. My lord, the inherent powers of the court are there, case by case, depending on a case the court may exercise. For one point I wanted to make regarding 34(4). 34(4) is not a suo motu power which can be exercised by the court. It has to be a party applying. And in the Kinari case at para 14, I will not take this court's time, but my lords may make a note. And in the Kinari Malik case at para 14, this aspect has been dealt with and pointed out. So, my lords, it is something where the court waits for one of the parties to exercise. But, my lords,
the language of the statute itself is very clear.
Yes. Yes, my lords. Language is, that's why. So, that's why I'm saying that as far as 34(4) is concerned, it's a completely different genre. When we are talking about modifications to be carried out by exercise of powers by the court, my lord, that has to be traced under 34. My lord, that's my submission. Then, my lords, may kindly come to so Kinari have dealt with, and my lords, finally, I would like to come to modern laminators, which my learned friend has already read out, Mr. Ritin Rai, that it has to be within the confines. And that confines, my lords, here I will comment one more submission. My lords had mentioned, may see 3.4 of my written submission, page 5. Learned Chief Justice had mentioned about section 15 of the Arbitration Act 1940. Now, of course, I'm aware that the case, I'm fully missed out there, but that case has said that section 15 provided for modification, etc., it's not there in the new act. But, my lords, when we look at the wider power of the court and the discretionary powers of the court, my lords, the contours of section 15 would be helpful guide in determining what should be the guardrails when the court is exercising its powers for modifying the award. And it has to be basically as what, my lords, I'm taking it from the words of the statute, basically a change, even if it's made, should not alter the basic structure of the award and the integrity of the award. This would constitute a legitimate modification under the act. And then, my lords, I made a reference to a Narayan Das case under the old act. And in that act, my lords, declaratory relief of ownership of property was given by the arbitrator without a consequential relief of possession. That's because the arbitrator was under the impression that the Bombay Rent Control Act applied and they would have to go to the Bombay Rent Control Act to take possession. That was found to be wrong, and under 15B, my lord, that was consequential relief was given, and they said, no, you can take possession. That's how it was interfered with. Then, my lords, the Pondicherry University case at 3.4.3, I've given an instance where a tribunal had not looked at the document at all. And so, my lords, it's not a reappreciation of evidence in that sense, my lords. It is looking at a document which has come, the court interfered there. And, my lords, my own case, my lords, 50 farmers for the last 15 years have been trying to seek compensation. This is under the NHAI Act. And, my lords, I would put it as a given case. What happens is this: it is accepted by both sides that there's a particular rate of compensation to be allowed. And when that rate is applied, unfortunately, the court says that, I'm sorry, I mean, the under 34, when the court applies that rate, it is set aside by the High Court, by the imbued order, saying you please go back by way of arbitration. There's no power to modify. My lord, those instances of injustice should be avoided. My lord, these are my respectful submissions. Deeply.
I'm basically appearing in the NHAI Act, and our submission is, my lords, whenever a land is being taken away, Article 300 capital A say authority by law. The law has not only to be substantive in terms of adequate compensation, which is given, my lords, market value of the land, but the procedure established also must be due process. My lords, here what happens is that a competent officer is appointed, which is a SDM. The arbitrator is a collector. Now, my lords, I cannot ask for enhancement under section 34 when I go for the first time before a judicial authority. And my lord, both these my lord sections are vulnerable. My lord, the virus is not a challenge. This court has held in a case of petroleum case, my lord, that a competent authority who is not legally trained cannot determine the compensation. Kindly just note, my lord, 2016-99 SEC. My lord, 2016-9 SEC 7-1. Perimeteria provisions. That competent authority determined, my lord, it was under the Petroleum Act, it is NHAI Act.
Yes,
And my lord, they have categorically stated that he should be a legally trained mind.
yes.
And my lord, they have struck down that if he is not a legally trained mind, he
But we are
cannot.
not dealing with striking down.
No, my lord, no, my lord, what we are saying is, my lord, a competent authority determines the compensation.
1 minute, how will we understand that? But we are not dealing with constitutionality.
No, my lord, I'm only pointing out. Then, my lord, arbitrator. Kindly see 3G4. 5, sorry, my lords.
Validity of 3G is under challenge itself.
Correct. My lord. All that I'm saying is the first time when we move to the court, my lords, it is before the district judge. Under my lords, kindly see, the first time when we move before the district
We have
judge.
understood your argument that until unless you reach power of
Enhancement. Yes.
power of modification into 34, it can lead to a lot of injustice because the provisions of section 34 have been made applicable under various enactments where the common people, even public law remedies, which has been pointed out, Mr. Nafte, is applicable.
Therefore, my lord,
So therefore, while construing 34, we have to take into account their public law remedies also, which are
34 has to be read differently, my lord.
So
Whenever my lord, a statutory arbitration.
it examine whether it's to be read separately or whether 34 itself is wider path. That's
Yes,
the one.
because my lord, I should have a judicial forum for the first time.
I think all argued by Mr. Nafte as well as Mr.
Well, my lord, all that we are saying is, well, here the judicial forum is coming for the first
Anyone else? No.
And my lord, this very well. So, my lord, the procedure established by law must conform the due process of a fair judicial determination, unfettered by section 434 restrictions also.
Okay, fine.
My lord, we should be able to provide the, my lord, and not relegate it back. Here also, my lord, rupees 50 was given. High Court has increased this to 10 times, my lord. Now,
Similar with Mr. Nafte and Mr. Swain.
very well.
We have filed.
Now, call out the name one by one. Don't take it.
Ashwin Shankar with Riddhi Nyati. This is for Shaft Shipyard, supporting the amendment. We have today opportunity to set right a problem that has been plaguing us for the last 10 years at least, which should have been done much before. Your Lordship has seen many litigants suffering. The choice is really to be made whether we drag our heels deeper into the existing problem on an imaginary obstacle under Section 5, or do we set right this opportunity which is today available? The Section 5, if my Lords may just see, Section 5 is not the obstacle, it's actually the gateway. The relevant lines my Lord reads is it says, shall intervene except where so provided in this part. That is a crucial part. Everybody has misread this to suggest that this is actually a limitation on the court's power. It says that when there is an opportunity, this is the window. Once you go inside, then there is no fetter as to what a court can do once it is faced with an award. So if I allow me just see the last phrase under Section 5, it is not the obstacle, it's actually the opportunity for the court to set right these. That's our first submission, my Lord.
Yes.
Second is, we have to be careful with what we allow the court to amend in future. So without a doubt, it must be those where the tribunal did not have a discretion. So statutory rights not being enforced, contractual rights not being enforced. To that limited extent, necessarily there must be the power we submit to the court, not a very wide, all-encompassing position. Third is what happens when neither party has raised the objection about the court's power to amend or not to amend. And the court under 34 has gone on to amend that because both parties argued with a tacit consent that the power is there to amend. What happens to the fate of all those matters? Because those decrees under 34 are now, those orders under 34.
That can be squarely answered as far as court's jurisdiction is concerned. By consent, you cannot confer subject matter jurisdiction.
But what is happening is orders are being set aside on points that were never argued before.
Maybe.
That is one of the issues.
You can't confer subject matter jurisdiction where it doesn't exist.
Then,
okay, we continue tomorrow, but within 25 minutes, whoever is there, please do not, only these names, one by one. And how much time, how many are there from the other side? How much space? There are four of you?
I'll give rejoinder, my lord, not more than 25, 30 minutes.
Fine.
4 or 5.
I have to start.
4 or 5 of us are there.
Okay, please now divide the time so that you end by 1 o'clock.
I just submit my compilation for one of the interviews.
Why are you submitting it now? And please sit down in the evening, make one compilation.
Yes, we'll do that. We'll ask.
They don't want multiple compilations.
We'll largely rely on,
Sit down in the evening, do one compilation. That's all. So 1 minute, whatever it is, make one compilation.
My lord, on this side, lordships, we have given a list. That list is there. That will be maintained as it is.
That
That
list
list of
which is
people.
there will be maintained, but not more than 5 minutes. If anybody crosses that,
Yes.
he'll be eating into somebody else's time.
Keep your head.